So can I start now?
By 1 minute, around 10 o'clock, one more minute. 9:59 now. We'll start by 10 or 10:1.
Just give me a heads up when I have to start.
Yes. Yeah. Yes, ma'am. Sir, do you want the participants to be unmuted and communicate with you over the session, or else you want to take it up at the end? Any questions?
I try to take up at the end because this is more like a classroom training.
Okay, I'll just
around 120 sections are there.
Yeah, I'll mute the participants and you can see the chat, and at the end you can unmute them.
Yes.
Then we can start almost 10 o'clock. Start.
I'll start?
Yes, ma'am, please.
Yeah. Okay. So how many participants now, Silva?
We have 22 or something will be joining. We have 47 registered.
Okay, fine. Okay, fine. Yeah. Good morning, friends. Welcome back to this refresher course for the exam prep of the IBC exam, IBBI exam. And today we have CA Ritesh Mittal, who is going to take us through individuals and partnerships and all the allied sections. As you all know, the code and the regulations are, as we have spoken for the past 2 days, the most important aspects of the examination and the case studies. And luckily for us, Ritesh has huge experience in handling cases, and he's also representing a lot in the NCLT and also preparing all the resolution applications, resolution plans, other allied documents. So we are going to have a very nice, very interactive session. It can be, if you all would like to take up your doubts with Ritesh with reference to the exam. He has been a part of our faculty group right from inception. So he would be able to advise people on the examination methodologies and how to clear the exam. So I will give you a brief introduction of CA Ritesh. He's a BCom, an LLB, an FCA, DISA, and an insolvency professional from Hyderabad. And he's a senior partner in Messrs. Sanjay Kumar Kothari and Co Chartered Accountants. And his expertise in the areas of company law, direct and indirect taxation, and legal matters for the past 15 years. He has been the interim resolution professional for companies like Thrive Solar Energy Private Limited, Mark Infrastructure Private Limited, SNS Starch Limited, and VRC Shoreline Enterprises Private Limited. And he's also been the resolution advisor for various resolution applicants for preparation of resolution plans and other allied documents. And he regularly represents before the NCLT on Insolvency and Bankruptcy Code and Companies Act matters. And he has presented many papers to various organizations and institutions like ICAI, ICSI, ICMAI, FAP, CCI, ASSOCHAM, Institute of Directors, IIM, Tax Bar Association, Imarticus, Osmania, and Andhra University, and various trade associations. He's got leadership roles in board positions as a managing committee member of the Federation of Telangana Chamber of Commerce, governing council member of Telangana and Andhra Pradesh Tax Bar Association for the term 2019-21, and he's currently holding the position of secretary. He's nominated member of the Regional MSME Facilitation Council of Meddal Malakkaigiri District. And he was the RCM of Southern India Regional Council of ICAI from 2016 to 2019, and managing committee member of the Hyderabad branch of SIRC from 2013 to 2016. So we are very fortunate to have him here with us as a faculty. And, I'm sure he's going to contribute a lot towards the knowledge of the participants to this program. Over to you, Ritesh.
Thank you, Revati, for organizing this program and for the introduction. And welcome all of you, and warm morning. And today we'll be taking up the part 3 of the Insolvency and Bankruptcy Code. which is for the individuals and partnerships. So probably you might have this time seen the structure of the paper. I'll take you to. So this is the website of the Insolvency and Bankruptcy Board of India, the regulator for insolvency professionals, IP, IPA, IUs, and valuers, registered valuers. So here what you can see is in the examinations, you have limited insolvency examinations. So here, as you know, the syllabus will be published at least 3 months before. That you will see in the part 4 of the code. So here from 1st of January 2021, this is the syllabus. Okay. So here the pattern will be all MCQs, and for each question it will carry 1 mark, and negative question will give you minus 0.05 of minus marks. Okay. And here in the legal framework, you can download the code, rules and regulations, circulars, notifications. It is better you have a BEAR Act which contains the code, rules and regulations. In fact, my suggestion would be to have a BEAR Act which has a very detailed index of not just the code, index of the rules and regulations also. Like for example, you have the Commercials BEAR Act, which has the index for rules, regulations and the code. Okay. Now, what happens is, like, what is the advantage of the index? It is not the content of the code which is difficult. What is difficult is to remember the dates. Okay. So the code is very simple when compared to our taxation, like where each line is very specific. It's a very simple language. There's no difficulty in remembering the code, but the issue comes in various dates. So what we have to do is, or what I have done in my examination is, whenever there is a particular section, wherever the numbers are coming in, I place them on the section. So you'll have the section number and the description of the section. Subsequent to that, I write all the dates. Okay. Then these numbers are being carried over to the index. So subsequently, if you see the index, there will be various days. So based on the days, you try to remember the section which is there inside. Okay. In case if you are not able to remember, go back and revise. With this, what will happen is the revision on the number of days will be more and more, and finally it will help you to revise 1 day before the examinations. Otherwise, it will be very difficult to remember the days. They were when we were doing the examination, many of our friends tried various ways. Some person tried like how many times 7 comes, how many times 14 comes, how many times 21 comes. But I felt this method is much more better and realistic rather than trying those sets. Okay. So now let's go with the presentation. I hope you are all able to see the PPT. Okay. Preparatory for insolvency examinations. So we will be taking part 3, individuals and partnerships. So this is the framework of the IBC. We have 5 parts. That is section 1 to 255. The 5 parts are divided into preliminary, that is part 1. Part 2 is CIRP. So IRP and liquidation for corporate persons. Then part 3 is the individuals and partnerships. So insolvency resolution process and bankruptcy for individuals and partnerships. Part 4 is the various regulations. Like for example, our CA Institute has come through an act. Okay, we have seen the website of the IBBI. Now, how did IBBI come into picture? Is there a act on IBBI? No, it is through this code itself the IBBI is formed, that you will see under the part 4, the various pillars of the 4 pillars of the IBC. Okay, you will see it there. That is coming in the part 4. And then part 5 are various miscellaneous sections wherein which will overwrite, as we have seen IBC overwrites all other acts. Those all sections are there in the miscellaneous. Okay. So this is how the arrangement of sections has happened. Now we'll be taking into part 3, which is section 79 to 187, total around 110 sections. Okay, will be the coverage for today's presentation. So insolvency resolution for individuals and partnerships. We have here 7 chapters. Chapter 1 is preliminary. So what does chapter 1 does? Chapter 1 gives us the definitions which are applicable for all chapters that will come under chapter 1. Chapter 2 is a fresh start process. Okay. Chapter 3 is insolvency resolution process. Chapter 4 is bankruptcy order for individuals and partnerships. Chapter 5, administration and distribution of estate of a banker. Chapter 6 is adjudicating authority for individuals and partnership firms. Chapter 7, offenses and penalties. Now, if we see, when we have seen into CIRP, how many stages were there? We had 2 stages, corporate insolvency resolution process, and then we had the liquidation process. So here we have the insolvency resolution process, which is nothing but chapter 3. Okay. And then in the liquidation part, we will be calling it as a bankruptcy order. So insolvency resolution process, that is chapter 3, and the bankruptcy order, which is chapter 4. Then what is this chapter 5? Administration and distribution of the estate of the bankruptcy. Now here what has happened is the bankruptcy process is again divided into 2 parts, chapter 4 and chapter 5. See what happens is once the bankruptcy order comes, the estate of the bankrupt vests with the insolvency professional, which will be called as the bankruptcy trustee here. So here, how will he administer and distribute? So how is he going to sell the assets? And then how is he going to distribute the amounts? Okay, that part will come under chapter 5. Okay, and chapter 4 talks about how it will be constituted, how the committee will be constituted, how the process will go flow. That broad levels are told under chapter 4. So chapter 4 and 5 is on bankruptcy. Chapter 3 is insolvency resolution process. Okay, then adjudicating authority, we have seen there in the case of CIRP, it was NCLT, NCLAT, and straightaway Supreme Court. Here it is debt recovery tribunals, DRT, debt recovery appellate tribunals, and then straightaway Supreme Court. And then finally, offenses and penalties. Then what is this chapter 2, fresh start process, section 80 to 93? So here a fresh start process is a separate sequence which is given for small creditors, okay, whose asset base is very less and whose debt amount is also very less. So the chapter has specified who can go for a fresh start. There are various numbers are given. Based on that number, if you are fitting in with that fresh start process, then rather than going to the insolvency resolution process, you can straight away go to the state process and free yourself. Okay, then we have the preliminary. So this is how the arrangement of chapters has happened. Now the IBC enactment came in May 2016 and the CRP commenced from December 2016. Individuals and partnerships with respect to corporate guarantors only. So that means this individuals and partnerships, still majority of the part is still not notified. Okay, but it is important from examination perspective. Okay, so that doesn't mean that though it is not notified, you will not get questions in the exam. You are going to get questions in the examination. But with respect to notification, December 2019, it is only with respect to a corporate guarantor. What does it mean? The company has taken a loan from a bank. I have given a guarantee, okay, on behalf of the company. So now if the bank is not able to recover the amount from the corporate debtor, CD, then they will catch hold of me as a guarantor. Okay, and my liability is going to be parallel. So they will invoke the insolvency resolution process, okay, under part 3 as an individual. So to this extent, as a corporate guarantor, the provisions has been notified, the regulations and rules has been notified. Apart from that, the regulations has not been notified. So that is the reason the section 2 of IBC, which talks about for whom the provisions has been included, there is a new subsection 2E, personal guarantors to the corporate data. What does it say? Just the provisions of the code shall apply to a company incorporated in the Companies Act, any other company governed by special act, a LLP, such other body corporate under any law for the time being in force the central government may by notification specify personal guarantors to corporate data, partnership and proprietorship firms, individuals other than persons referred to under clause E above. Okay. Then, so that means from first day of December 2019, the code is effective for corporate guarantors. So effective from first day of December 2019, what should I study? I have to study the Insolvency and Bankruptcy Code 2016. Okay. Then there are 4 rules or regulations. I will say 2 rules and 2 regulations which were notified. What are they? The Insolvency and Bankruptcy Application to Adjudicating Authority for Insolvency Resolution Process for Personal Guarantors to Corporate Data rules. The Insolvency and Bankruptcy Application to Adjudicating Authority and Bankruptcy Process to Personal Guarantors to Corporate Guarantor rules 2019. And then there are 2 regulations, the IBBI Insolvency Resolution Process for Personal Guarantors to Corporate Data regulations and IBBI Bankruptcy Process to Personal Guarantors to Corporate Data regulations 2019. Okay. So now when we are seeing there are 2 rules and 2 regulations. So now there is 1 code, 2 rules, 2 regulations. What is the difference between a rule and a regulation? Rules are notified by the government, central government. Regulations are governed by the board. The board can provide the regulations. So that is the difference. Now, where do we have rules? We have seen rules in the case of CARP, Application to Adjudicating Authority rules, whereas the corporate insolvency resolution process were regulations, the liquidation process were regulations. Okay. So similarly here, the application to adjudicating authority is a rule. Okay. The application to adjudicating authority for bankruptcy process to personal guarantors is also a rule, whereas the subsequent part, so initially what do? We apply to the adjudicating authority, then the adjudicating authority will approve the application and then the insolvency resolution process starts. Okay, so till the application to the adjudicating authority, this is our rule part. Subsequently comes the regulation. Now what we have seen in the case of CARP, once you file an application under section 7 or 9 or 10, okay, making the rules under application to adjudicating authority rules, and the application adjudicating authority accepts the application and the CARP is initiated. What happens? It goes into CARP. From CARP, suppose if there is no resolution plan comes in, or the resolution plan is not accepted by the COC members or the adjudicating authority, what happens? It will straight away trigger liquidation. Here it doesn't happen. Triggering the bankruptcy process is not automatic. So first we have to trigger the insolvency resolution process. What we have seen the CARP process by section 7, 9, 10, that process was triggered. Here the triggering of the insolvency resolution process will happen. In case the process is not successful, in that case, again, the trigger has to be made for the bankruptcy process within the specified period. So it is not automatic that if it fails, the bankruptcy process will not be automatic. That is the reason here. How many application to adjudicating authority rules are there? Twice. Initial is the first part, application to adjudicating authority for insolvency resolution process. The second is application to adjudicating authority for bankruptcy process. So initially we'll apply for the tribunal for insolvency resolution process. If it fails, then again we will apply for the bankruptcy process. Similarly, we have the insolvency resolution process for personal guarantors regulations, the first part. Then in case if it fails, the second part regulations are there under bankruptcy process for personal guarantors. So something like in this way, you have seen the Income Tax Act is there, you have income tax rules. In Companies Act, how do we have? We have for each chapter of Companies Act, we have rules. Okay, here what happens is for various parts, it will be some part there will be a rule, some part there is a regulation. So for part 3, what are we supposed to study holistically? We are supposed to study the code, and then these 4 regulations, 4 not regulations, 2 rules and 2 regulations. Okay, I hope I'm clear. So this is the framework for adjudicating authority for chapter 3, individuals and partnerships. As we know, for CIRP process, the default amount earlier was 1 crore. From 24th of March 2020, this amount has been made 1 crore. Earlier it was 1 lakh. So minimum default, which was 1 lakh earlier, is now 1 crore. Whereas in the case of non-corporates, the minimum default amount is 1,000 and the maximum amount is 1 lakh. Okay. Now here, what happened in the corporate insolvency resolution process? There were 2 stages: resolution stage and liquidation stage. The adjudicating authority were the NCLT, National Company Law Tribunal, and the next level is NCLAT, and straight away then the apex body was Supreme Court. Here what has happened is, with respect to individuals, again it has been divided into personal guarantors for corporate data other than personal guarantors for corporate data. Personal guarantors for corporate data, the adjudicating authority will follow the CD, the appellate tribunal, for which is applicable for the company. So that means if I am a guarantor for a company, the adjudicating authority which is applicable for that corporate debtor, where the registered office of the company is situated, okay, that will be the adjudicating authority. So suppose if the corporate debtor is in Hyderabad, the NCLT bench will be of Hyderabad, whereas if it is in Chennai, the NCLT bench will be of Chennai. So it follows the corporate debtor. So here what will happen is, I am a personal guarantor. So though suppose if the corporate debtor address is of Hyderabad, but I am residing in Chennai, my case will come up to the hearing for NCLT where the corporate debtor is situated. So it will follow the same tribunal where the corporate debtor is situated. So it will go to the adjudicating authority as NCLT and not to the DRT. Because DRT till now, they have not yet started taking up the cases for IBC. They are still under surfacing cases are presently going on there. Okay. So apart from that, personal guarantors, okay, so that is for individuals other than personal guarantors and partnership firms, the adjudicating authority will be the DRT, DRAT, and the Supreme Court. Now there are, as I have told you, in the CIRP, there are 2 stages: CIRP stage, that is corporate insolvency resolution stage, and the liquidation stage. Here also we have 2 stages: the insolvency resolution process stage and the bankruptcy stage. The only thing is, from the insolvency resolution process to bankruptcy stage, the trigger is not automatic. There the trigger was automatic. If the CIRP fails, straight away liquidation is triggered, which will not happen here. Again the trigger should go on, again the application has to be filed for bankruptcy separately. This is the framework for adjudicating authority for chapter 3. Now coming to the chapter 1 preliminary, section 78 to 79, we'll take up few of the sections. Qualifying debt. Okay, so now it talks about qualifying debt. Then second section talks about excluded debt. So there is a debt. Okay, now in that debt, some part is a qualifying debt, some part is a excluded debt. So now we'll see what is a qualifying debt. Qualifying debt means amount due which includes interest and other sums due. So amount due including interest and other sums in respect of the amount owned under the contract by the debtor for a liquidated sum. So amount should be liquidated amount. It should be a quantifiable amount. Okay, if it is not quantifiable amount, then it will not be a part of the qualifying debt, either immediately or at a future date, but does not include. So from the qualifying debt, these will not be included. What are they? Excluded debt. Subsequently, we have various debts which will not be part of the qualifying debt. They will be called as excluded debts. We'll come to the next slide. So exclude the excluded debt. The debt to the extent it is secured. Secured debts also, you remove it from the qualifying debt. Any debt which has been incurred 3 months prior to the date of application to the fresh start process. So you are making a fresh start process now. And what am I trying? I have taken loans from various persons just immediately. So the intention is anyway, I'm going for the fresh start process. Okay, so I don't have to pay them subsequently. Fair enough. So for that purpose, if you have taken, so any debt which has been incurred 3 months before prior to the date of application of fresh start process are also not to be included. So what is the meaning of qualifying debt? Qualifying debt are those sums, okay, which I will be able to reduce my amount or reduce my liability in the course of insolvency resolution process or the fresh start process or the bankruptcy process. Okay, so these are the debts. So now suppose if I am a creditor, I will be happy if the amount is there in the qualifying debt or if I am there in the excluded debt or unsecured debt. Let us see what is excluded debt. Excluded debt means a liability to pay fine imposed by a court or tribunal. So what has happened? I have done a huge, there was a major fine which was imposed by me for around crore of amount. Now I don't have that much of amount. What I do, I go into insolvency resolution process and say that now I don't have to pay this amount. Not possible because this is a excluded debt and it is not a qualifying debt. Liability to pay damages for negligence, nuisance, or breach of statutory, contractual, or other legal obligations. So if I am liable to pay damages for negligence, nuisance, or breach of statutory contract or other, so if there are damages of this sort, they will be a part of excluded. Liability to pay maintenance to any person, another any law for the time being forced. So suppose if one person is getting divorced and he is supposed to make the maintenance amount has to be paid. Okay. Now what happens is he'll say, I'll go to insolvency and I will not make the payment of the maintenance. Not possible because it is a excluded debt. Liability in relation to a student loan. What I have done, I am a student. Okay, I have joined a big MBA college. I have taken a loan of around 40 to 50 lakhs. Subsequently, when I come out, I see the market is not very good. No one is ready to hire me. And I have a loan outstanding with the bank for around 50. And now from the last 4 or 5 years, the interest is accumulated. Now somewhere 70, 80 lakhs of the amount outstanding is there. So is it possible that I get into the insolvency process and get my student loan waived off? Not possible because it is a excluded debt. Liability in relation to a student loan is also excluded. Any other debts as may be prescribed. So these all debts are excluded debts. You cannot bring them within the purview of the insolvency and bankruptcy code. So what debts you can bring in? You can only bring in qualifying debt. So one thing is clear, qualifying debt is other than excluded debt. The second part, a debt to the extent it is secured. So suppose if I have taken a loan from a bank and I have mortgaged my property, why that loan is not coming to the qualifying debt? Because the banker has the option to sell that property and get the amount recovered. So that means to the extent it is secured, the debt will not come under the qualifying debt. So it will go straight away, go to SARFAESI and recover the amount, and it will not come part of the qualifying debt. This is a huge difference here. See what happened if you have seen in the case of CIRP, the committee of creditors are financial creditors, irrespective of the fact whether they were secured or unsecured. If there are no financial creditors, then it was 18 plus 1 plus 1. But in general case, the committee of creditors were financial creditors, and they can be secured or unsecured. The extent, the concept of security was coming in only at the stage of liquidation and not at the stage of CIRP. Whereas here in part 3, that if it is secured, straight away it goes outside the purview of the qualifying debt. So that means he is totally an outsider. So once he is an outsider, he will not be a part of the committee of creditors to the extent it is secured. Yes, for the unsecured portion to that extent, he will be a part of the qualifying debt. So that is very clear. So excluded debt is outside, debt to the extent it is secured is outside. Any debt which is incurred just 3 months before, prior to the date of application of fresh start process is also outside. So that people don't take undue advantage of the code. Then this is about the debt. This now coming to asset. Now you will have what assets has to be included. Now suppose as a bankruptcy trustee, he'll be taking all the what assets has to be taken. I'll take all assets except for these excluded assets. So these excluded assets will be outside the purview of the insolvency and bankruptcy code. What are these excluded assets? For the purpose of this part, includes Unencumbered. Unencumbered means on which there is no lien has been created. No lien has been created. Unencumbered books, tools, books, vehicles, and other equipment as are necessary to the debtor or the bankrupt for his personal use or for the purpose of employment, business, or vocation. So these are the tools, books, vehicles, and other equipment which are necessary for the bankrupt or the debtor for his personal use. For example, as a chartered accountant, what is necessary for me? My books are my tools. Okay. Now, for example, there might be a mechanic, for him some set of tools will be there. So those set will not be a part of the included asset, they will be excluded asset. Then unencumbered furniture, household equipment, and provisions that are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. So I need some basic furniture straight away. I cannot live on the roads. So some basic furniture, household equipment should be there, and provisioning should be there for my basic domestic needs. To that extent, it also becomes a part of the excluded asset. Unencumbered personal ornaments of such value as may be prescribed of the debtor or his immediate family, which cannot be parted with in accordance to religious usage, like mangasut, all these personal ornaments which will be there, the amounts will be notified in the regulations. So that will be a part of the excluded assets. Unencumbered life insurance policy or pension plan taken in the name of the debtor or his immediate family. So life insurance policy, again, part of the excluded asset. An unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. So one single dwelling unit is also outside of such value as may be prescribed. So we have seen so many times prescribed. What are these amounts which are prescribed? How much is the quantum of these amounts? So rule 5 of the application to adjudicating authority for insolvency resolution process for personal guarantors to the corporate debtor, rules 2009 says, excluded asset. For the purpose of subsection 14 of section 19, the value of unencumbered personal ornaments under clause C of subsection shall not exceed 1 lakh rupees. So personal ornament up to 1 lakh. Unencumbered single dwelling unit owned by the debtor under clause E cannot exceed, if it is in dwelling unit is in urban area, 20 lakh rupees, rural area, 10 lakh rupees. Okay. For the purpose of this rule, rural area shall have the same meaning as assigned to in the National Rural Employment Guarantee. Urban areas have other than rural areas are urban areas. So now the limit is for personal ornaments 1 lakh. For single dwelling unit, so only one single dwelling unit is allowed. Urban areas up to 20 lakhs, rural areas up to 10 lakhs. Now, coming to the next definition, associate of the corporate debtor. Associate is nothing but the related persons. We have seen in CIRP, a related party of the corporate debtor cannot be a part of the COC member. So here, first of all, we have to see what is a related party. So the definition is given under section 79, subsection 2. Associate of the corporate debtor means a person who belongs to the immediate family of the debtor, a person who is the relative of the debtor or a relative of the spouse of the debtor, a person who is in partnership with the debtor, a person who is a spouse or a relative of any person to whom the debtor is a partnership, a person who is an employer of the debtor or employee of the debtor, a person who is a trust, free of a trust, who is a beneficiary of the trust, includes a debtor, or the terms of the trust confers powers on the trustee which may be exercised for the benefit of the debtor, a company where the debtor or the debtor along with his associate owns more than 50% of the share capital of the company or control the appointment of the board of directors of the company. For the purpose of this subsection, relative with reference to any person means who is related to if another, if they are members of the same family, one person related to another in such manner as may be prescribed. So this is the definition of an associate. Then coming to section 78, insolvency resolution process for individuals and partnerships firm. This part shall apply relating to a fresh start, insolvency and bankruptcy of individuals and partnership firms where the amount of default is not less than 1,000 rupees, provided that the central government by notification specify a minimum amount of default of such higher value, which shall not be more than 1 lakh rupees. So the amount, the quantum of default minimum amount should be 1,000 rupees, or it can maximum extend it to 1 lakh. Whereas in the CIRP, it was 1 lakh and maximum it can be made to 1 crore. Presently, that limit has been taken up to maximum amount of 1 crore from 24th of March 2020 onwards. Okay, so here what it says, two parts. Fresh start process, there is no limit quantified, no limit. In the case of insolvency and bankruptcy, there the limit is specified of 1,000 rupees. Now, so this is the notification wherein the insolvency resolution process for personal guarantees has been brought in from 15th of November 2019 is the notification date, and it says from first day of December 2019. So these all sections, clause E of section 2, as I've shown you earlier, it is for personal guarantors. That separate clause has been included. So these all sections with respect to personal guarantors has been included. That means when we read the code, it will say debtor, 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 debtor. But when we read the rules and the regulations, it will say personal guarantors. Why? Presently, the two rules and two regulations has been brought in only for the personal guarantor. So the code gives a holistic picture. The code is not just for personal guarantors. The code is for everyone. Okay. Whereas the rules and the regulations has been brought in only with respect to the personal guarantors. So wherever you see the debtor in the rule, you have to straight away imply that there's personal guarantor. Here in the wherever you see debtor in the code, you have to imply the personal guarantors in the rules and regulations. Going forward, suppose what will happen, the entire code is notified, then what will happen is we will have separate rules and regulations for the other than personal guarantors, or the partnership firms also will be brought in. So that time probably we might get different rules and regulations for them, because here it is going to NCLT, that they will go to DRT and DRT. But overall, the process has been given in the guidelines, and already the cases have been with respect to the personal guarantors have been started. Okay, now coming to yes. Now coming to the rules and regulations part 3. As I have told you, in the code we have the chapter 3. Okay. Now, and chapter 4. The chapter 3 talks about insolvency resolution process. Chapter 4 talks about the bankruptcy order. So with respect to the insolvency resolution process, first stage is application to adjudicating authority for personal guarantor rules. The second stage is insolvency resolution process for personal guarantor regulations. Similarly, as I said, for bankruptcy also, it is not an automatic process. So again, the application for adjudicating authority for bankruptcy process has to come, and then the bankruptcy process for personal guarantor regulations comes in. So we have the 4 regulations. Now coming through the fresh start process. Section 80 to 93. Okay. Now, 80 talks about eligibility for making an application, application for fresh start process, appointment of RTP, examination of application by RP, application or rejection of application by adjudicating authority, effect of admission of application, objections, applications, general duties, replacement. These are all the sections are there. Okay. Now coming through eligibility. Who can get into a fresh start process? As I have told you, a fresh start process is a subset. As of total part 3, it is a subset, a small subset. Okay, what does it say? It is for small persons. Okay, who are those small persons? Suppose my gross annual value income is less than 60,000. My aggregate value of the assets is less than 20,000. My aggregate value of the qualifying debt. Qualifying debts are those debts which can be adjusted. So how much is the aggregate value of the qualifying debt? 35,000. It should not exceed. I am not an undischarged bankrupt. So who is an undischarged bankrupt? From the date the order is passed, okay, the order is admitted till the order is passed, in this period I will be called as undischarged bankrupt. So I am not an undischarged bankrupt. I does not own a dwelling unit. Earlier we have seen I should own only one single dwelling unit. That too amount of 20 lakhs in the case of urban areas and 10 lakhs in the case of rural areas. Now for fresh start process, as I have told you, it is again a subset, a small subset. So here what is the condition? I should not be having any dwelling unit itself. Then the fresh start process, insolvency resolution process and bankruptcy process is not subsisting against him. So already there is no such processes. So fresh start process or the insolvency resolution process or the bankruptcy process as of now is not subsisting against him. No previous debt process under this chapter has been made in relation to the preceding 12 months. So earlier 12 months, there should not be any fresh start process. So that means if once I have gone into the fresh start process, again, if I have to go for a fresh start process, there should be a gap of 12 months of the date of application for fresh start. Okay. So that means what you can do here, see, as I have told you, write those points on the section. So section 80 fresh start process, you will have in your index on the top right there, gross annual income 60K. Then aggregate value of the assets. So you call it as AA 20K. Qualifying debt, aggregate value of the qualifying debt 35K. Not having not an undischarged bankrupt, not having a dwelling unit NDU. Okay, no fresh start process in the earlier 12 months. So that way, if you write a line, you will be able to remember the points which are there inside. So that becomes a part of your index. That is how I used to proceed. Okay, so that means these amounts are applicable for petty vendors. Okay, small person vendors are there. But because if you see annual income should be less than 60, annual value of the asset should be 20,000, aggregate value of the qualifying debt. So maximum benefit what he will get is only 35,000. Okay, then so that means who is going to become a resolution professional for such vendors where the maximum benefit what he is be able to get is 35,000. The aggregate value of the qualifying is 35,000. So obviously, if you see this process to become a resolution process, to become a resolution professional in the case of fresh start process is not very remunerative. So probably it might happen that there are a bunch of banker is there. He is having around 100 cases, 200 cases, all of the cases you might be taking into the single bench and proceed through all these cases. In that, it might be remunerative. Otherwise, if you start with such individual cases, I don't see it will not be any remunerative also. Now coming to application, eligibility to make an application. A debtor who is unable to pay his debt and fulfills the conditions. So these are the conditions. So first the condition is I am not able to pay the debt. Second is I am fulfilling the conditions. What are those conditions I have seen earlier? Then shall be entitled to make an application for the fresh start process for discharge of the qualifying debt under this chapter. So the discharge is only with respect to the qualifying debt. So what is excluded from the qualifying debt? What we have seen, excluded debts are outside, secured debt is outside, any debt which I have incurred 3 months before the fresh start process is also outside. So that means it is only with respect to the qualifying debt. Again, here you have seen this one of the condition, the aggregate value of the qualifying debt also should not be beyond 35,000. So then if these conditions are satisfied, I am not able to repay and the conditions are satisfied and with respect to the qualifying debt, then I may apply, the debtor may apply either personally or through a resolution professional for a fresh start under this chapter in respect of the qualifying debt to the adjudicating authority. Once the application is made under the fresh start process, what will happen? The interim moratorium shall commence on the date of filing the said application in relation to all the debts. See, here we have seen the fresh start is applicable only with respect to qualifying debt, but the interim moratorium is respect to all debts. It is not that we are saying the term moratorium for the first time. Moratorium we have seen earlier also in the case of CRP. Once the application for CRP is accepted and the company goes into CRP process, moratorium is applicable. What happens in the case of moratorium? All legal suits which are going against the company will be stayed. Okay, and no creditor will be able to proceed against the company. So that is where the moratorium is starting. But at what stage the moratorium started? It is after the application was accepted by NCLT. But here the beauty is it is not at after that. At the once the application is filed itself, the interim moratorium starts. Why is there interim moratorium? See, if you see, individual insolvency is a painful process for an individual, okay, and it is a stressful process for the family. So to give them the protection, it is at the stage when the application itself is filed, they are going to get the interim moratorium. Okay, once the application is accepted, then they will get the final moratorium. Okay, then shall cease to have effect on the date of admission or rejection of certificate. So this interim moratorium will start from the date of application till the date it is accepted or rejected. Okay. Then what happens during this moratorium period? During this moratorium period, any legal action, legal pending proceedings pending in respect of any of that debt shall be deemed to have been stayed. So all actions and proceedings will be stayed. Okay, no court can proceed. What they will give is they'll only give the dates. They'll state there. No creditor shall initiate any legal action or proceedings in respect of such debt. The application under Section 80 shall be in such form and manner and accompanied by such fees as may be prescribed. So presently, for fresh start process, it is not yet notified. What has been notified is only insolvency resolution process with respect to personal guarantor. So this fresh start process is not yet notified. Then the application shall contain the following information supported by an affidavit, namely a list of all debts. So with this, I have to give my list of all debts owned by the debtor as on the date of such date, along with the details relating to the amount of each debt, interest payable, name of the creditor to whom such debt is owed, the interest payable on the debts and the rate thereof stipulated in the contract, the list of securities in respect of such debts, the financial information of the debtor and his immediate family for up to 2 years prior to the date of application, the particulars of the debtor's personal details as may be prescribed. So these additional details has to be given along with the application. The reasons for making the application, the particulars of any legal proceedings which to the debtor's knowledge has been commenced against him, the confirmation that no previous fresh start process under this chapter has been made in respect of the qualifying debts of the debtor in the preceding 2 years. Because we have seen one of the condition is you should not, there was no previous fresh start process within the earlier 12 months. So for that, I am giving affidavit or confirmation. Yeah, that is one of the conditions. So now if you see here, I have written here on the top in short, the list of all debts, AD and list. Okay, how much is the interest payable, INT payable? Okay, list of securities, SEC list. Okay, financial information for 2 years, debtor's personal details, PD, reasons for filing. LP stands for legal proceedings. No previous fresh start process within 12 months. Now write this on the index. You will be able to remember. In case you daily revise them. In case if you are not able to remember, go back and then once or twice if you do this revision, the point will be clear. Okay. Then, as we have seen that in this case, the debtor has option to file himself or he can file through a resolution professional. So debtor files the application through a resolution professional, where the application under 80 is filed by the debtor through a resolution professional. The adjudicating authority direct the board within 7 days of the date of receipt of the application and shall seek confirmation of the board that there are no disciplinary proceedings against the RP who has submitted such application. So since it has come through that RP, it is the responsibility of the adjudicating authority to ensure that there is no disciplinary proceedings pending against the RP. Now, how will the adjudicating authority have the information? Adjudicating authority doesn't have this information. So what they'll do is they will direct this application to the board and ask the board to check and confirm. So the board shall communicate to the adjudicating authority in writing. So adjudicating authority shall direct the board within 7 days. Once they receive the application within 7 days, they'll direct this application to the board. The board, once it receives, it will confirm the appointment of the RP who files an application, rejects the appointment of the RP who files an application nominated by resolution professional, and the board shall nominate RP within 10 days of receiving the direction from the adjudicating authority. So the adjudicating authority will ask the board within 7 days whether there are no disciplinary proceedings pending against RP, and the board within 10 days either should confirm or reject. Then that has to be done within 10 days. Okay. What if the debtor files the application himself? Where the application under Section 80 is filed by the debtor himself and not to the RP, the adjudicating authority. Now the adjudicating authority has to provide the name of the RP. So within 7 days of the receipt of application, we'll ask the board to nominate a resolution professional. The board shall nominate a resolution professional within 10 days of receiving of the direction issued by the adjudicating authority. The adjudicating authority shall by order appoint the RP recommended or nominated by the board. The resolution professional appointed by the adjudicating authority shall be provided a copy of the applicant of fresh start process. So if the debtor files through the resolution professional, they will check, okay, you have come through this name. The adjudicating authority within 7 days will ask the board to check. Board within 10 days will accept or reject. Else, if he files himself, the adjudicating authority will ask the board to give the name within 7 days, and the board will give the name within 10 days. So that's all. So now here, if you remember 7-10, it's enough, because both the cases, whether he files through the resolution professional or through himself, if you remember the days, 7 days for his adjudicating authority and 10 days for the board. The sections we are able to remember. Then Section 83, the resolution professional shall examine the application made under Section 1080 within 10 days of his appointment. So once appointment, the resolution professional is going to examine the application and submit a report to the adjudicating authority, either recommending acceptance or rejecting the application. Now see, the preliminary verification of the application is done by the resolution professional. So he is going to examine the application, check whether the criteria are fulfilled, and then he is going to make his recommendation to the adjudicating authority, and that has to be done within 10 days. So this process was not there in CRP. CRP, what happens is Section 7, 9, and 10, there was no, the RP was coming in only after the initiation of CRP. Whereas here, he is coming in right at the stage of the application. So it is his job to verify the application. So his process has started at day 1. The report shall contain the details of the amounts mentioned in the application, which in the opinion of the RP are qualifiable debts and liabilities eligible for discharge under subsection 3 of 92. So what are the qualifying debts? Out of this, how many are eligible for discharge? He will give a report on that. The RP may call for further information or explanation in connection with the application as may be required from the debtor or any other person who, in the opinion of the RP, may provide such information. The debtor or any person, as the case may be, shall furnish such information or explanation within 7 days of the receipt of the request. So once the RP calls for information, so he has to give the information within 7 days. The RP shall presume that the debtor is unable to pay his debts at the date of application if, in his opinion, the information supplied in the application indicates that the debtor is unable to pay his debts and there is no reason to believe that the information supplied is incorrect or incomplete. He has a reason to believe that no changes in the financial circumstances of the debtor since the date of application, enabling the debtor to pay his debt. So these are some of the assumptions which he is going in there. So here in Section 83, what is the timelines we have to remember? We have to remember 10,7. 10 is the time given to RP to review the application and provide his opinion or recommendation either to accept or reject. And if he calls for some information, the debtor's duty to provide the information within 7 days, information or explanation. That is 10,7. The resolution professional shall reject the application if in his opinion the debtor doesn't satisfy the conditions. You have seen the conditions, he is not satisfying there. The debtor discloses in the application the debts are not qualifying debts. So the debts disclosed in the information are not qualifying debts. What type of debt? There might be secured debt. We have seen that excluded debts are there. It might be excluded debt. He might have put student loan or penalties. So if they are not qualifying debts also, he'll have to reject it. So obviously, if I am a creditor, I want my debt either to be excluded debt or my debt should be a secured debt, and I don't want my debts to be a qualifying debts. Because once if it is qualifying debts, there is a possibility that I might be discharged without getting any payment. So I, as a creditor, my intention is to also always ensure that my list is not there in the qualifying debt. It's either there in the secured debt or excluded debt. The debtor has deliberately made a false representation or omission in the application or with respect to the documents or information submitted. The RP, the resolution professional, shall record the reasons for recommending, the accepting or rejecting the application in the report to the adjudicating authority. So it is not just his recommendation. Why he is recommending the acceptance or rejections, those reasons also has to be given, and that copy has to be given to the debtor also. Once that is received, the adjudicating authority within 14 days from the date of submission of report to the RP pass an order either admitting or rejecting the application. The order passed under subsection 1, accepting the application shall state the amount which has been accepted as qualifying debt by the resolution professional and other amounts eligible for discharge under 92 for the purpose of fresh start process. A copy of the order passed by the adjudicating authority along with the copy of the application shall be provided to the creditors mentioned in the application within 2 days of passing the order. So once the application is made, adjudicating authority will take the application and within 14 days it will pass the orders. Okay, and it has to be given, the copy has to be given to the creditor. So it is 14, comma, copy to creditor in 2 days. You have to remember. Then on the date of admission of application, the moratorium period shall commence in respect of such debt. So till now, till the date of admission, we had interim moratorium. So now it is final moratorium. Here also the same point. All pending legal actions, pending proceedings has stayed subject. The creditor shall not initiate any legal actions. Same thing is coming here also. During the moratorium period, the debtor shall. Now, say are certain of the restrictions of the debtors here which has been imposed. What are they? He cannot act as a director of any company or directly or indirectly take part, be in concerned in the promotion, formation, or management of the company, not dispose of or alienate of the assets. He cannot sell or alienate of my assets. Inform the business partner that I'm going into fresh start process. Be required to inform prior to the entering into a financial or commercial transaction of such value as may be notified by the central government, either individually or jointly, that I'm going. So before I enter into a contract of such an amount, I'm supposed to tell them that I'm undergoing a fresh start process. Disclose the name under which he enters into business transactions if it is different from the name of the application admitted under 18. So suppose I have some proprietorship firms, then I have to disclose the names also under which I have going there. And I cannot travel outside India except with the permission of the adjudicating authority. The moratorium ceases to have effect at the period of 180 days beginning from the date of admission. So from the admission, it has to be closed within 180 days unless the order admitting the application is revoked under subsection 2 of 91. Now, there is a possibility that the RP subsequently finds that the initial application, because initially he has given an opinion, but subsequently he finds that there is an issue. So he can apply for revocation also under subsection 2 of 91. So that is also possible. So this moratorium should end normally within 180 days, or if the revocation order has come till that date. Now, there might be objections from the creditors. I feel that my debt has been included in the qualifying debt, but it should be a part of the excluded debt. I feel that my amounts were incorrectly included. My amount was, had been higher or it has been reduced. In such cases, on these grounds, I can make an objection to the resolution professional. A creditor mentioned in the order of the adjudicating authority under section 84 to whom the qualifying debt is owned. So it is only with respect to the creditor to whom qualifying debt is owned within a period of 10 days from the receipt of order under 84. Object only on the following grounds. Two grounds are only permissible. What are they? Inclusion of debt as a qualifying debt, incorrectness of the details of the qualifying debt specified in the order. The creditor may file an objection by way of application to the resolution professional. The application under subsection 2 shall be supported by such information and documents as may be prescribed. The RP shall consider each objection under this section. Then the resolution professional shall examine the objections and either accept or reject the objections within 10 days of the date of application. So debtor is given 10 days, creditor is given 10 days of time to make objection. Once he receives application, resolution professional is given again 10 days of time to examine the objections and to accept or reject. The RP may examine on any matter that appeared to him to be relevant in the making and make a final list of qualifying debt. So what he'll do is he'll make a final list of qualifying debt. On the basis of the examination, the RP shall prepare an amended list of qualifying debt for the purpose of discharge order and make an application to the adjudicating authority in section 90 or take such other steps as may be required. Then creditor made an application to me. RP thought that no, my earlier application was correct, and again he has rejected. So how can the creditor, what can the creditor, agreed creditor and debtor do? He can now straight away go to the adjudicating authority. So the debtor or the creditor who is agreed by the actions taken by the RP under section 86 may, within 10 days of making such decision, make an application to the adjudicating authority challenging such action on any of the following grounds. Namely, the RP has not given an opportunity to the debtor or the creditor to make a representation, that the RP colluded with the other party in arriving at the decision, that the RP has not complied with the requirements of section 86. In such cases, they might go for the adjudicating authority. The adjudicating authority shall decide the application within 14 days of such application and make an order is deemed fit, where the application has been allowed by the adjudicating authority. So it is not just adjudicating authority has allowed and another of the RP is rectifying back. No. So that means the reasonable opportunity was given to the RP under section 86. 10 days time was given to him to rectify. He has not done. So now comes the penalty provisions for the RP. It shall forward its order to the board and the board may take action as may be required under chapter 6 of part 4 against the resolution professional. That is a disciplinary mechanism. There might forward the name. The debtor shall make an application to the RP. So these are the general duties of the debtor. Okay, all information relating to his affairs, attend meetings and comply with the requirements of the RP in relation to the fresh start process. Inform the RP as soon as possible any material error or omission in relation to the information or document supplied. So suppose he comes to know that there is a material omission or error, he has to inform. Any changes in the financial provision at the date of application, from the date of application to the impact. Suppose I have earned good amount of money. See, this happened in the case of hospitals. Many of the hospitals who were going into CRP, okay, all of a sudden, in the case of COVID, now they have started making huge profits. So the overall entire idea, the scenario itself has been changed. So in such cases, any change in the financial circumstances after the date of application and where such change has an impact on the first start process, he has to intimate to the RP. Where the debtor or the creditor is of the opinion that now here the debtor or the creditor thinks that this RP has to be changed. Okay, he's not listening to us or whatever the reasons. Now they want to be changed. What is the section? Section 89 gives a power to them to change the RP. So where the debtor or the creditor is of the opinion that the RP under section 82 is required to be replaced, he may apply to the adjudicating authority for replacement of such RP. What will the adjudicating authority will do? Once again, they get 7 days of time to the board. Board will take 10 days and appoint a new professional. So the adjudicating authority shall, within 7 days of the receipt of application, make a reference to the board for replacement. The board shall, within 10 days of the reference of the adjudicating authority, recommend a name of insolvency professional to the adjudicating authority against whom no disciplinary proceedings are pending. The adjudicating authority shall appoint another RP for the purpose of the fresh start process on the basis of recommendation of the board. So this is again replacement for RP. The date, if you remember, 7-10. Now if you see 7-10 is coming for the third time here. The adjudicating authority may give direction to the RP replaced to share all the information to the new RP in respect of the fresh start process, to cooperate with the new resolution professional in such matter as may be described. Because now what has happened is some part of the work is done by the old RP and now the new RP has come. So he is supposed to provide all the information and support to the new resolution professional so that he can carry forward the job. Direction for compliance of restrictions, etc. Now here what happens is many of the cases there is a problem to the resolution professional that debtor or the creditor are not compliant, are not listening to them. Now in such cases he can go to the adjudicating authority for directions. That is section 90. The resolution professional may apply to the adjudicating authority for any of the following directions, namely compliance of any restrictions referred to in subsection 3 of 85 for the non-compliance of the debtor. So any restrictions are given on the debtor. He is not complying with that. Compliance of the duties of the debtor under 88. There are many of the duties. He is not complying to that. The RP can go to the adjudicating authority. The RP may apply to the adjudicating authority for directions in relation to other matters under this chapter where no specific provisions has been made. So for other matters also he can go and can approach the adjudicating authority and get a direction. Revocation of order admitting application. As I said, it is not that once the application is admitted, subsequently I have as a RP, I have come to know that this application, there was some malified manner or willful failed to comply some of the provisions. Then the RP again may go to the adjudicating authority asking for revocation of the admission of order. So that is under 91. The RP may submit an application to the adjudicating authority seeking revocation of its order under section 84 on the following grounds, namely, if due to any change in the financial circumstances of the debtor is ineligible. So due to the change in financial circumstances, we have seen the various criteria. The income should not be of this rate. The amount has increased. Okay, he's ineligible. Non-compliance by the debtor, the restrictions imposed in section 85 subsection 3, or if the debtor has acted malified manner or willfully complied with the provisions of this chapter, the adjudicating authority within 14 days. So if you see every time the adjudicating authority, the days are 14 days only. Okay, of the receipt of the application under subsection 1 may by order admit or reject the application. On passing of the order admitting the application, the moratorium and the fresh start process shall cease to have effect. So till now the moratorium was going, that will cease to have effect, and the copy of the order passed by the adjudicating authority under this section shall be provided to the board for the purpose of recording an entry, and this information shall be given to the board. Now finally coming to the discharge order. The objective of the entire fresh start process is to discharge the person from his debts. So the RP shall prepare the final list of qualifying debt and submit such list to the adjudicating authority at least 7 days before the moratorium comes to an end. So 180 days were given for the moratorium, so at least 7 days before he has to make an application to the adjudicating authority. The adjudicating authority shall pass a discharge order at the end of the moratorium period. So at the end of the moratorium is 180 days. So here minimum 7 days time is given to the adjudicating authority for discharge of debt that are from the qualifying debts. So with this, what will happen once the discharge order comes, the debtor is discharged of his qualifying debts. Okay. Now, without prejudice to the provisions of subsection 2, the adjudicating authority shall discharge. So is it only the debt or other sums also? From the following liabilities, namely penalties in respect of the qualifying debt from the date of application till the discharge order, interest including penal interest in respect of the qualifying debt from the date of application till the discharge order, any other sum owned by the contractor in respect of qualifying debt from the date of application till the discharge. So it is not that the amounts till the date of application, it is interest, penalties, interest, other sums from the date of application till the discharge orders are also included. Okay, the resolution professional shall perform his functions and duties in compliance with the code of conduct. We'll see that under the part 4, under the chapter resolution professional, there is a set of code of conduct which is given to that, and here it is referring to the resolution professional that he has to follow strictly to the code of conduct. So now what happens is, in these sections you write those dates. So this is how your index will look into, and this will be helpful for a quick division. Now suppose 80 eligibility for making an application. What is this gross annual income? 60k. Okay, gross annual income. Then aggregate value of the asset is 20k. Qualifying debts is 35k. Okay, then no fresh start process in 12 months. He is not no dwelling unit. Okay, so and there was one more, I think. Okay, so this way if you write the list, it will be helpful for the easy friends. Okay, this is what my suggestion to you. So this is again a flow chart example. So what is it? Comply with the requirements, filing an application, interim moratorium comments, appointment of RP. He examines the application, adjudicating authority decides, final moratorium starts, objections by the creditors. Based on that, he might amend the list or final list of qualifying debt, and finally a discharge order. Okay. So this is a fresh start process, a small subset of the insolvency resolution process where the amounts are very less. So basically, whom you can see, small farmers are there, small petty vendors are there. Those are the persons I see in fresh start process. Okay, and we have to see who will come forward for a RP of a fresh start process where the amount itself are so low, but still it is as on date is not notified. We have to see how it been taken. Now coming through the chapter 3, which is the main part, insolvency resolution process. This is in lines with the CRP process which we have seen under corporate insolvency resolution process. Here it is called as insolvency resolution process. The next part is chapter 4 is bankruptcy order. So that is nothing but in lines with the liquidation order. Bankruptcy order, administration, distribution of the estate of a bankrupt is made as a separate chapter, and bankruptcy process is made as a separate chapter. So that bankruptcy order is made under 2 parts. Finally, chapter 6 is adjudicating authority and offenses and penalties. Okay, insolvency resolution process. The sections are from 94 to 120, and along with that, we have to read the application to adjudicating authority rules. Okay, and the regulations with respect to insolvency resolution process. So application rules and the regulations for insolvency resolution process, both. And this is only with respect to personal guarantors. So the code is with respect to the personal guarantors and other than personal guarantors, partnership firms, but these regulations and rules are only with respect to the personal guarantors. Okay. Now, some part is very much same what we have seen in the fresh start process. In fresh start process, the application was made by the debtor through himself or by the RP. Here also, the application can be made by the debtor through himself or by the RP. Whereas here under insolvency resolution process, the creditor can also file an application through himself or through a resolution professional. That is the main sections 94 and 95, the trigger sections for insolvency resolution process, like section 7, 9, and 10. Here the trigger sections are 94 and 95. 94 with respect to debtor, and creditor himself, if he wants to file, he'll file under 95. So 95 for creditor and debtor for 94. Similarly, in what we are saying under section 10. Now, what does it say? Filed by the debtor, rule 6 in form A, filed by the creditor, form C. So these rules are only with respect to the personal guarantors. Fees is 2,000 rupees. With respect to debtor who has committed a default on debt other than excluded debt, either personally or through a resolution professional. In the case of a partnership, by majority of the consented partners, they can file a petition under section 94. With respect to the creditor, he has to file under form C. Fees is 2,000 rupees. Now, in fees with respect to CRP was, in case of operational creditor, it was 2,000 rupees, whereas in the case of financial creditor, it was 25,000 rupees. Here it is 2,000 for both, either individually or jointly through other creditors, directly or through resolution professional, if the debtor fails to pay within 14 days of service of demand notice in form B. So application to adjudicating authority, insolvency resolution process for personal guarantors, rules 2019, because these forms, fees is all referred to under this rules. Okay. Debtor's ineligibility to file an application under 94. The debtor shall not be entitled to make an application where he is already undischarged bankrupt. So already a bankruptcy proceedings have been filed and he is undischarged bankrupt. He is already undergoing a fresh start process. He is already undergoing an insolvency resolution process, or he is already undergoing a fresh start process. In that case, he cannot go, he is not entitled to get into make an application. The debtor shall not be eligible to make an application if under this chapter he has been admitted in respect of the debtor within the period of 12 months preceding the date of submission of an application under this chapter. So already application has been filed within preceding 12 months. Is not eligible. The application shall be in such form and manner as may be prescribed. Application for initiation by a creditor. Now coming to 95.4, we have seen application under subsection 1 shall be accompanied with details document. The debts owned by the debtor to the creditor or creditors submitting the application for insolvency resolution process on the date of application. The failure of the debtor to pay the debt within the period of 14 days of service of notice of demand and the relevant evidence of such default or non-repayment of debt. Now, we have seen under section 9, before filing a petition under NCLT, the creditor has to serve a notice to the corporate debtor for 10 days. Here, under insolvency resolution process, the creditor has to issue a notice to the debtor and the time given is 14 days here. So earlier in CRP, the notice period was 10 days. Here under insolvency resolution process, the notice period is 14 days. Then withdrawal of application. Rule 11 of the application to adjudicating authority rules, the adjudicating authority may permit withdrawal of application under rule 6 or 7 as the case may be, before the admission on the request made by the applicant, after the admission on the request made by the applicant, if 90% of the creditors aggregate for such withdrawal, an application for withdrawal shall be in form D. This is in line with section 12A in CRP process, wherein what happens is once CRP is initiated, it is up to the applicant. If he wants to withdraw before the constitution of COC, he can withdraw, or if it is making an application after constitution of COC, that application the RP will take to the COC within 7 days, and he has to get the approval of the COC with by 90%, and then he'll make that application through to the NCLT. Similar lines also we have the rule here before the admission by the applicant himself, because COC is not constituted, whereas after the admission, that application will go to the creditors and the creditors aggregate has to accept for 90%, and the form has to be in form D. There under CRP it was form FA. Now, insolvency, okay, that's it. So this is a small flowchart how this happens. Application for insolvency resolution process. Again, here the first step will be RP will be appointed. RP will give his opinion. Based on the opinion, adjudicating authority will pass the orders. So there is a very different set where the RP's roles is starting stage at the stage of applicant itself, and not at the stage of after admission, what we have seen in the CRP. So day one, the role of RP is there. Within 10 days, he's supposed to give the opinion. What we have seen in the fresh start process, the similar points are there here. Adjudicating authority will take 14 days. Then finally, the adjudicating authority will admit or reject. Then admission, the adjudicating authority will give a newspaper advertisement calling for claims. So people are going to submit the claims, and the list of creditors will be prepared by the RP. So creditors, list of creditors will be prepared. Then based on the data, he will tell how I am going to repay these creditors. So he, in consultation with the RP, is going to prepare a repayment plan. Because in CRP, what was happening, as a running company, we were trying to sell the asset. But here what will happen is, data in consultation with the RP will give a repayment plan. Okay, these are the persons which I have to supposed to pay. These are my qualifying debts, and these are my assets. So how am I going to pay that? This repayment plan he's going to prepare. That repayment plan he will submit to the submission of repayment plan by RP to the adjudicating authority on his own report on the plan. So that RP might submit it to the adjudicating authority, or it might go to the committee of creditors. The committee of creditors may accept the repayment plan. Fair enough. So then if they accept the repayment plan, then the repayment plan will go to the adjudicating authority. It will be approved. In case they ask for modifications, no, you are saying that you'll pay so much. No, this is not acceptable. Then again, it will go to the debtor, and he will accept those each and every modifications. Okay. And then once the repayment plan is finalized, it becomes binding on all the debtors and creditors. Okay. And if it is not, and suppose if this repayment plan has been failed, or at the initial stage of the applicant itself, the RP, what has happened in the 10 days itself, he has rejected the application, then in such cases, they have to again file for the bankruptcy process. Okay, because here what is happening is, what is the key difference between the insolvency resolution process and bankruptcy process? In the insolvency process, the RP is going along with the debtor, whereas in the bankruptcy process, the estate vests in the hands of the bankruptcy trustee or the resolution professional. Subsequently, in the case of the bankruptcy, will be called as a bankruptcy trustee. What we have seen in the CRP stage, CRP was called as a IRP, then RP liquidator. Here it is called as the resolution professional stage, and the second stage where he goes into bankruptcy, he will be called as a bankruptcy trustee. Okay, so the assets will vest to the hands of the RP, will be called as a bankruptcy trustee. Then he is going to sell off the assets and make the payments. So, but here a fair chance is given to the debtor to prepare a resolution plan and dissolve himself, discharge himself based on the resolution plan or the repayment plan. Okay, so this is how he'll prepare a repayment plan. In CRP, it was called as a resolution plan, because which was submitted by the prospective resolution applicants. Here the repayment plan is prepared by the debtor himself. Okay, that repayment plan is being submitted to the committee of creditors for approval. So this is a small in nutshell. Now again, moratorium, as we have again seen, there are two stages of moratorium. Immediately at the filing of application, the initial moratorium or the interim moratorium is there. And once it is admitted, the final moratorium comes into picture. Okay. So from the date of filing till the admission, and final moratorium 180 days. And interim moratorium is any debts. And final moratorium is states with respect to debts. Okay. Applicable to debtors as well, there the debtor shall not transfer, alienate, encumber his assets or the legal rights. So this is with respect to the moratorium, interim and final. Now, public notice and claims by the creditors. The adjudicating authority shall issue a public notice. So the first stage is the RP submits the application, the adjudicating authority accepts the application, and then once it is accepted, the adjudicating authority shall issue a public notice within 7 days. In CRP, the public notice was issued within 3 days by the interim resolution professional. Here it is issued by the adjudicating authority within 7 days of passing the order under section 10, inviting claims in Form B from all creditors within 21 days of such a issue. So now there the creditors were given 14 days of time, and which can be extended up to maximum 90 days. Here the time given is 21 days for accepting of claims. The notice shall include the details of the orders admitting the application, the particulars of the resolution professional to whom the claims have to be registered, and the last date for submission of claims. The notice shall be published in at least one newspaper, English newspaper, and one vernacular newspaper, which is in circulation in the state where the data resides, affixed in the premises of the adjudicating authority, placed on the website of the adjudicating authority. In CRB, where was it published? It was one in English newspaper, one is vernacular language, where the address of the corporate debtor is there, or his principal address is there, okay, and his principal address. It has to be affixed at the website of the board, and it has to be affixed at the website of the person, corporate debtor. Here it is affixed at the premises and at the website of the adjudicating authority. That is where the changes are, key changes. The creditor shall register claims with the resolution professional by sending the details of the claim by way of electronic means or through courier, post, speed post, or registered post. In addition to the claim, the creditor shall provide to the RP personal information and such particulars. So the form B will provide what are the details, has to be all the invoices, everything, okay, has to be provided along with his ID proof, address proof has to be attached there. Okay, one verification will be there. So these details he'll provide it. How is he going to submit it? It can be either through electronic or through courier, speed post, or registered post. Whereas in the case of CARP, in case of a financial creditor, it has to be only by electronic means. In the case of operational creditor, it can be by electronic means or a physical means. Whereas here it has given option of both the options are given here. Then once the claims are received, the resolution professional shall prepare the list of creditors on the basis of the information disclosed in the application filed by the debtor under 94 or 95, as the case may be, claims received by the RP under section 102. So that is, second part is very clear. Based on the claims received by the RP, he is preparing the list. What is this? Based on the application filed by the debtor. See, there is a debtor under 94 or 95. We have seen these are the two trigger sections 94. Based on that applications, he can straight away include them in the list of creditors. Whereas in the CARP, the petition might have been filed under section 7 or 9. Once it is the CARP is initiated, the applicant is supposed to file again the claim form. Whereas with this section, what it says is the applicant need not file the claim form again. The creditor, suppose I have initiated as a creditor, I have initiated the application. So I need not file the petition again. Okay, the resolution claim again. The resolution professional shall prepare the list within 30 days from the date of notice. So I have been given, the resolution professional is given 30 days to prepare the list of creditors. Then this is the beautiful thing, repayment plan. This repayment plan has to be prepared by the debtor in consultation with the RP. And this repayment plan will say how the assets will be realized and how the payments is going to happen and who is going to administer the repayment plan. Okay, this everything will be there. Okay, the debtor shall prepare in consultation with the RP a repayment plan containing a proposal to the creditors for restructuring of his debts or affairs. The repayment plan may authorize or require the RP to carry on the debtor's business or trade on his name or on his behalf or his name, realize the assets of the debtor, administer or dispose of the funds. The repayment plan shall include the following, namely, justification for preparation of such repayment plan and reasons on the basis of which the creditors may agree upon repayment, provisions for payment of fee to the RP, and such other matters as may be specified. Now, once the repayment plan is prepared, the RP is going to summon the meeting of the creditors. The resolution professional shall issue a notice calling for the meeting of creditors at least 14 days before the date fixed for such meeting. The RP shall send the notice to the meeting of creditors prepared under 104. The notice shall state what are the components of the notice: the address of the adjudicating authority, the report of the RP on the repayment plan, accompanied by the repayment plan, statement of affairs, the copy of the report of the RP, proxy form. Suppose if some person doesn't want to come and he wants to come in proxy, the proxy form, including the electronic proxy voting, shall be placed. The meeting of the creditors shall be conducted in accordance with the provisions of section 109, 1110 and 111. The meeting of the creditors may decide to approve, modify or reject the repayment plan. Now the creditors have received the repayment plan. They can approve it. Okay, fair enough, done, accepted. They might modify it. No, this way we have to work. Or they may reject it, not required. This plan is not enough. We will go to bankruptcy. We can get higher amounts there. Okay, we'll reject. The RP shall ensure that the modifications are suggested by the creditors. Consent of the debtors should be obtained for each modification. Suppose if you are approving or rejecting, well and good. But if you are suggesting modifications, these modifications has to be accepted by the debtor, because finally the agreed person is debtor. He is supposed to make the payment. So he is going to accept the modifications for each suggestions which has been made by the creditor. So the RP shall ensure that each modifications are suggested by the creditor, consent of the debtor shall be obtained for each modification. The RP may, for sufficient cause, adjourn the meeting of the creditors for a period not more than 7 days at a time. He can adjourn the meeting for 7 days at a time. The resolution professional shall convene the first meeting of the creditors and shall convene the meeting by giving such notice to other participants as decided by the creditor. In case if they want to include other participants, then they can include them. For them, the time limit for notice is 48 hours. The resolution professional shall convene a meeting of the creditors on the request of the creditors having 33% of the voting share of creditors. So 33% of voting share says, yeah, we should have a meeting. Okay, fair enough. Then it becomes a mandate on the resolution professional to have a meeting. If they feel that not required, that meeting is not required, straight away the resolution professional can take the repayment plan and straight away apply to the NCLT. The notice under this regulation shall be served on accordance on every participant to the address provided to the RP in accordance with regulation 12. Unless otherwise provided in the code, any decision of the creditor shall require approval of more than 50% of the voting share of each of the creditors who voted. So the decision of the creditors, so minimum voting is 50% to make the resolutions to be approved. Okay, a meeting of the creditors shall be quorate. Oh, this is the quorum. If the creditors present, at least 33% of the voting share are in person, by proxy or through video conferencing. So the person can be in person or through by proxy, or he can attend by video conferencing, but the quorum should be minimum 33%, provided that the creditors in the meeting may modify the percentage of voting share required for quorum in respect of future meetings. So first meeting they said, no, it's not required 33, they can change the quorum for subsequent meeting. Where the meeting of creditors could not be held for want of quorums unless the creditor have previously decided otherwise, the meeting shall stand adjourned at the same time, place on the next day, and that day no quorum shall be required. So meeting shall automatically adjourn. So that is, see, one more thing is, in case if the RB wants to have a meeting, ensure that the next day is also free for him, because sometimes the quorum doesn't come in. He's supposed to adjourn it to the same time, place, and suppose he has booked a place wherein it is not available on next day. Don't do that. Ensure that at least next day is also free for that place. Voting rights in the meeting of creditors. The creditor shall be entitled to vote at every meeting of the creditor in respect of the repayment plan in accordance with the voting share assigned to him. So every creditor will vote based on the voting share assigned to him. The resolution professional shall determine the voting share to be assigned in manner specified by the board. Creditor shall not be entitled to vote in respect of for an unliquidated amount. So if there is a debt which the amount is not quantifiable, the debt will not be considered. The creditor shall not be entitled to vote in the meeting of creditors if he is not the creditor mentioned in the list of creditors. So if he is not there in the list of creditors, he will not be considered. Or if he is an associated, we have seen in the case of CRP, any person who is related to the corporate debtor, he will not be a part of the COC member. Here also, he will not be an associate. We have seen the definition in the initial sections. Okay, so if he is an associate of the debtor, he will not be a part of the creditors meeting. Voting, how the voting will happen. The resolution professional shall take a vote of creditors present at the meeting on any item listed for voting. At the conclusion of the meeting, the RP shall prepare the minutes of the meeting, including the names of the creditors who voted against, for, or abstained. So for each resolution, who voted, who abstained, and who voted against. Okay. The resolution professional shall circulate the minutes to all participants of the meeting within 48 hours. Seek the vote on items listed for voting in the meeting of creditors who were not present or did not vote for meeting by electronic means, where the voting were kept open for at least 24 hours from the circulation of minutes. So 48 hours, within 48 hours, he has to circulate. Then whoever have not voted, give them again 24 hours of time for vote. At the end of the voting period, the resolution professional shall record the decisions. Okay. I write on the agenda items along with the names of creditors who voted against, abstained from the voting after considering the voting of the meeting and through electronic means. The RP shall circulate the copy of the records made under subsection 4 to all the participants within 24 hours of the conclusion of the voting. The creditor who is entitled to vote at the meeting of creditors shall be entitled to appoint an individual who shall not be an associate of the guarantor as a proxy to attend and the vote. So the proxy who is being attending, he should also not be related. For the purpose, the creditor shall deliver Form C duly completed to the resolution professional at least 24 hours prior to the meeting of the creditor. So this Form C or proxy form has to be given to the resolution professional at least 24 hours prior to the meeting of creditors. The proxy may vote on electronic means on behalf of the creditor. The proxy may also vote. Now coming to the secured creditor. What happens to the secured creditor? Is he going to vote or is he not going to vote? Is he going to be a part of the creditors meet or is he not going to participate? We have seen in the initial section, qualifying debt doesn't include secured debt. Okay, so now a secured debtor has an option either to relinquish his right. Okay, he says, okay, I am going to relinquish my right. In that case, my preference will be changed for payment and then I will be entitled to vote. Then if I say, no, I am not going to relinquish my right, he will submit the affidavit, then he shall entitled to vote only with respect to the unsecured amount. So that will be considered only to the unsecured amount, if any. Approval of the repayment plan by creditors. The repayment plan or any modifications to the repayment plan shall be approved by a majority of more than 3/4 in value. So we have seen earlier 50% for normal agenda items, but for the approval of repayment plan, majority of 3/4 in value of the creditors present in person or in proxy and voting on the resolution in a meeting of creditors. Report of the meeting of the creditors on repayment plan. The RP shall prepare a report of the meeting of creditors on repayment plan. So now he is going to give a report of the meeting of creditors. The report shall contain what? These are the items. Whether the repayment plan was approved or rejected. Okay, if approved, any modifications, the resolutions which are proposed at the meeting and decisions taken, list of creditors who were present and represented in the meeting, such as the information which he feels the adjudicating authority needs as appropriate. The resolution professional shall provide a copy of the report of the meeting of creditors to the debtor, creditor, and the adjudicating authority. Now, adjudicating authority, after receiving the report, shall by an order approve or reject the repayment plan on the basis of the report of the meeting of the creditors submitted by the resolution professional under 112, provided that where a meeting of creditors is not submitted. As I've said, minimum 33% of the creditors should say that there should be a meeting. In case if there is no meeting, straight away the repayment plan went to the adjudicating authority. It can happen like that also. Provided that where the meeting of creditors is not summoned, the adjudicating authority shall pass an order on the basis of the report prepared by the RP under 106. The adjudicating authority approving the repayment plan may also provide for directions for implementation the repayment plan. So they may also say these are the directions for implementation of the repayment plan. Where the adjudicating authority is of the opinion that the repayment plan requires modifications, it may direct the resolution professional to reconvene a meeting of the creditors for reconsideration of repayment. So in case if they feel that it requires modification, again it will send it back to the resolution professional and to be passed with the creditors. Where the adjudicating authority has approved the repayment plan under section 114, the repayment plan shall take effect as if proposed by the debtor in the meeting and be binding on the creditors mentioned in the repayment plan. So once this repayment plan is approved, it will be binding. It will be, the effect is as if it is a proposal from the debtor and it is binding on all the creditors. That is the objective here. But if the adjudicating authority rejects the repayment plan under 114, the debtor and the creditor shall be entitled to file an application for bankruptcy under chapter 4. So that is what I'm saying. Here, if the repayment plan is rejected, it is not an automatic, bankruptcy is not an automatic trigger. debtor or the creditor has to make an application for bankruptcy again under Chapter 4. A copy of the order passed by the adjudicating authority shall be provided to the board for the purpose of recording an entry in the register report 196. A copy will be provided to the board.
Sir, sorry to interrupt, sir.
Yes,
so
yes,
can we
yes.
have a break for 10 or 15 minutes? It's almost.
We'll have 10 minutes because see, I have a hearing at 1:30. So
Okay.
we'll try to close it. So
We have for 5 or 10 minutes.
5
sir.
minutes we'll have, sir. Yes, done. Okay.
Thank you.
So 5, it is 5:35. 5:35, 5:40. Yes, sir. Thank you.
11:38 or 11:40 will start. We'll pause for 5 minutes.
Or should I close these two slides are there? So straight away we'll go to bankruptcy and we'll have a break there.
Yes, sir.
Okay. Yes. Okay. Discharge order on the basis of the repayment plan, the RP shall apply to the adjudicating authority for the discharge order in relation to the debts mentioned in the repayment plan, and the adjudicating authority may pass a discharge order. The repayment plan may provide for early discharge or discharge on the complete implementation of repayment plan. The discharge order shall be forwarded to the board for the purpose of recording. Repayment plan coming to end prematurely. What happens is, debtor gave a repayment plan, but subsequently he could not make the payments to the creditors as were determined. Okay, so somewhere the repayment plan got stuck in between, because repayment plan is not a single stretch. It goes into phases. This is how I'm going to get the money. This is going to pay the payments. So in case he comes to a dead end, or he is not able to make the entire closure of the repayment process or the repayment plan, then we say it as coming to an end prematurely. So a repayment plan shall be deemed to have come to an end prematurely if it has not been fully implemented in respect of all the persons bound by it within the period as mentioned in the repayment plan. Where the repayment plan comes to an end prematurely, the RP shall submit a report to the adjudicating authority which shall state the receipts and payments made in pursuance of the repayment plan. So based on the repayment plan, how much receipts and payments have come, the reasons for premature end, and the details of the creditors who are still not satisfied. The adjudicating authority shall pass an order on the basis of the report submitted by the RP that the repayment plan has not been completed. Now, what will happen with this? It is equivalent to like the discharge order will not come, and the debtor or the creditor whose claim under repayment plan has not been satisfied will be entitled to go for the bankruptcy process under Chapter 4. So this is a brief comparison between the personal insolvency and corporate insolvency. Now here in personal insolvency, what are the key differences? Application by creditor. In personal insolvency, there is no classification whether it is a financial or operational, whereas in CRP, there was a distinction which is a financial creditor or an operational creditor. COC member should be only a financial creditor. Now, admission or rejection, adjudicating authority decides the matter on report of the RP. So here the RP came into picture at the initial stage, whereas there the RP comes only after the admission stage. Withdrawal is possible, same 90% consent, same here also. COC, they don't call as a COC, we say it as list of creditors. Their COCs, no consent, general list is creditors is prepared. Moratorium is there, but here additionally in personal insolvency, we call something called as interim moratorium is also there. In the personal insolvency, there is a distinction between secured and unsecured creditors. Secured creditors as such are outside unless until he gives affidavit saying that I relinquished my right. Whereas CRP, we don't make the difference between a secured and an unsecured creditor. Repayment plan requires 3/4 value, whereas there it is 66%. Rejection straight away in CRP it leads to liquidation. Here separately a application has to be filed. Implementation and supervision of repayment plan, RP is appointed to supervise and implement. There the resolution plan provides a mechanism for implementation and supervision. This is the key difference between the CRP and insolvency resolution process. So here next chapter is Chapter 4, bankruptcy order for individuals and partnerships. Here we'll take a break for 5 minutes. Yes, thank you. welcome back. I hope you are able to see the screen. Bankruptcy order for individuals and partnerships.
Sir?
Yeah, you are able to see the screen?
Yes, sir, we are able to see
Yes,
it.
individuals. So welcome back. So we'll start with the next chapter 4, bankruptcy order for individuals and partnerships. I just tell you the brief. What have we covered? We have covered preliminary. Therein we have covered what is a qualifying debt, what is excluded debt, what are excluded assets. Then we have seen who is an associate. Then we discussed what are the fresh start process, what are the conditions for fresh start process, who can make the application. The application can be made by the debtor or through a resolution professional. Interim moratorium starts. Then finally, the NCLT, the adjudicating authority admits the application. The final moratorium starts. Then the discharge order comes into picture. Then we have seen the insolvency resolution process. Insolvency resolution process is in lines with the corporate insolvency resolution process, but again, the major differences are here at the stage of filing itself, the interim moratorium starts. The application can be made by the debtor or the creditor, and claims are a public announcement is made. List of creditors is formed, and then the prepayment plan is being prepared by the debtor in consultation with the resolution professional, and then the repayment plan is put forward to the creditors, and once they approve the creditors, it goes to the NCLT, and then the NCLT approves the repayment plan. It becomes binding on all the creditors. Then we have seen premature end of the repayment plan, where the repayment plan cannot be proceeded further due to some issues, okay, or due to some non-compliances. The repayment plan ends prematurely. So now coming through the bankruptcy process. So the bankruptcy process has the sections are from 121 to 148, and the trigger for bankruptcy is not automatic. So again, the application to adjudicating authority for bankruptcy process rules are there, and the bankruptcy process regulations are there. So we have to study the code along with the rules and regulations. So we'll key with some of the key definitions. Okay. What is a bankrupt means? Bankrupt means a debtor who has been adjudged as bankrupt by the bankruptcy order. So a debtor who has been adjudged as bankrupt, then each of the partner in the firm where the bankruptcy order is under 126 has been made against them. So if it is against the firm, each partner will be called as a bankrupt, and any person adjudged as an undischarged insolvent is also a bankrupt. What is an undischarged insolvent? Mr. A is adjudged as insolvent on December 12, 2019, and the date decided by the court to settle his liability is January 1st. So judgment came on 2019, and the date decided the settlement of liabilities happened on January 1st. So in this period of December 12 to January 1st, he'll be called as undischarged insolvent. Bankruptcy means the state of being bankrupt. Bankruptcy debt means, in relation to the bankrupt, means a debt owned by him as on the bankruptcy commencement date. Till now, we have seen what was a qualifying debt. Now it will be called as a bankruptcy debt. In relation to the bankrupt means any debt owned by him. So any debt which the bankrupt has owned as on the bankruptcy commencement date, any debt from which he becomes liable after the bankruptcy commencement date, but before his discharge. Okay. See, finally, let it be fresh start process or insolvency resolution process or the bankruptcy process, finally, the debtor will be discharged of all his debts. So here also, from the bankruptcy commencement date till the discharge, here also in this process also the bankrupt will be discharged in this process. So within this period, by reason of any transaction entered into before the bankruptcy commencement date, so the transaction was entered earlier, but the debt came into picture after the bankruptcy commencement date, BCD, till the date of discharge. Any interest which becomes a part of it, that is a bankruptcy debt. Bankruptcy commencement date. What is bankruptcy commencement date? The date on which the bankruptcy order is passed. Here also the application will be made first. Interim moratorium will come. Then the bankruptcy order is passed. Since the bankruptcy, so the date in which the order was passed, that date it is called the bankruptcy commencement date. So bankruptcy order means order passed under adjudicating authority 126. Bankruptcy process means a process against the debtor under so-and-so chapter. Bankruptcy trustee means the insolvency professional appointed as a trustee for the estate of the bankrupt under 125. So earlier in the last chapter, he was called as a resolution professional, RP. Now that person will be called as a bankruptcy trustee. See here what happens, various terminologies are given. At the end of the day, it is the RP who will be now called as a bankruptcy trustee. Okay, like we have seen in CRP, it was called as IRP, RP, liquidator. Here it is called as RP and now bankruptcy trustee. Now this is again the flow chart here. Application for bankruptcy order. So first thing is application for bankruptcy order has to be made. Now here the RP, till now we have seen under fresh start process and the insolvency resolution process, the RP is going to review the application. That stage is not there because here the trigger happens only when under three situations. Worst situation is in the first stage, the RP reviews the application and he rejects the application saying that it is made majorly to defraud creditors. Second stage where the resolution plan was repayment plan was rejected by the adjudicating authority. Third case where the repayment plan came up prematurely. So in these three cases, you can apply for a bankruptcy order. Okay. Now, once it is done, nomination for a bankruptcy trustee will be done. Okay. We will see the days of 7-10. Okay. Then the bankruptcy order, the bankruptcy commencement date. Then again, a public announcement will be given. Okay. So that calling for claims. Again, the creditors committee will be formed. The list of creditors will be done. Okay. Meeting of the creditors will happen. In the meanwhile, the estate of the bankrupt will come into the hands of the bankruptcy trustee. He will administer and distribute the assets. What is the meaning of administering? Take the charge of the assets, start selling the assets and start distributing. So this is called as completing the administration and disbursement. Then he'll prepare a report. This report will be put in the committee of creditors and this committee of creditors will approve the report and finally the discharge, the debtor will be released. Okay. Now coming to the points by section 121. Application for bankruptcy. As I've said, there are three cases which will trigger the application for bankruptcy. An application for bankruptcy of a debtor may be made by the creditor individually or jointly with other creditors or by the debtor. So here the creditor may make individually or with other creditors. If we have seen into CIRP, under section 7, application can be made by the applicant by the financial creditor himself or jointly, whereas section 9 application has to be made only individually. So here the creditor can make an application individually or jointly or it can be made by the debtor also to the adjudicating authority following circumstances. What are those circumstances? 10.4. What is 10.4? Our resolution professional application rejects as it is for defrauding creditors. So we have seen the first stage. Before the application goes to the NCLT, the resolution professional has to check the application and has to give his comments. So wherein the resolution professional has rejected the application and he thinks that it is to defraud creditors, it will trigger section 10 and the creditors can file an application for bankruptcy here. Okay. Then 115.2, adjudicating authority rejects the repayment plan. 118.3, premature end of repayment plan. So these are the three trigger sections for bankruptcy. The application for bankruptcy has to be filed within 3 months. So it has to be filed within 3 months from the date of order passed by the adjudicating authority. Where it is in the case of the firm, the application has to be filed by any of its partners. So now again here there are two trigger sections, 122 and 123. 122 is by the debtor. Okay. Now, as we have known, presently the regulations have come only for corporate guarantors. So if you read the regulations, they will say it as guarantor. So that's the reason I have written as debtor, guarantor. Fees is 2,000 rupees. Debtor is a firm. The application has to be made by partners. Creditors also, it is the form B. 2,000 rupees is the fees. Regulations are rules. Application to adjudicating authority for bankruptcy process for personal guarantor rules 2019 are the rules which are governing these points. Application for debtor. The application for bankruptcy by the debtor shall be accompanied by. So here the debtor is filing. So when he is filing, what is he going to get along with the application? The records of the insolvency resolution process, the statement of affairs of the debtor, a copy of the order passed by the adjudicating authority. So records of insolvency resolution process, statement of affairs and order passed. The debtor may propose the IP as a bankruptcy trustee. The application for the bankruptcy by the debtor shall not be withdrawn without the leave of adjudicating authority. The application for bankruptcy under this case, in the case of a deceased debtor, may be filed by the legal heir. In case the debtor is deceased, the legal heir can file the application for bankruptcy. Now coming to 123, application by creditor. The application by the creditor shall be accompanied by the records of the insolvency resolution process, the copy of the orders passed by the adjudicating authority permitting the creditor to apply, details of the debts owned by the debtor to the creditor as on the date of application for bankruptcy, such other information. What is missing between 122 and 123? 122, we had statement of affairs of the debtor. Now, statement of affairs of debtor were available with the debtor, but it is not available with the creditor. So that is the reason the statement of affairs of the debtor is not a part of the application in the case of application by creditor under 123. The creditor may propose the IP as a bankruptcy trustee. The application for bankruptcy by the debtor shall not be withdrawn without the leave of adjudicating authority. Now, what is the role of the security creditors? Again, what we have seen security creditors, he has two options, either to relinquish his right and become part of the creditors, or take his security and be excluded, and his name will be included only to the extent of unsecured part. The same flowchart what we have seen is given here also. Effect of application. What will happen once the application is filed? Immediately the interim moratorium will commence, irrespective of the fact it is made under 122 by the debtor or 123 by the creditor. Interim moratorium will start. Moratorium shall cease to have effect once the application is approved. So then, where the application has been made in relation to the firm, the interim moratorium shall operate to all the partners of the firm. Appointment of the bankruptcy trustee. Now, 7-10, if you remember, 7 days is given to the board to refer to the adjudicating authority. 7 days is given to the adjudicating authority to refer to the board. Board is given 10 days to confirm the name. So there are two things. Appointment in the appointment in 122, 123, the name of the bankruptcy trustee is already proposed. Then the straight away, the adjudicating authority will recommend whether any disciplinary proceedings is there. Then the board has to confirm. If there is no name, then they will apply and the adjudicating authority will get the name within 7 days, and which has to be approved by the board within 10 days. This is section 125, 7-10. So now straight away, in case if you see this is coming for the third time, the same 7-10 number. So we have seen in fresh start process, we have seen in insolvency resolution process. Now we are again seeing the same numbers in 7-10 in bankruptcy trustee also. So once we remember 7-10, all the three sections look similar in nature, because here also before the admission is there, the bankruptcy trustee is appointed. The adjudicating authority shall pass the bankruptcy order within 14 days of receiving the confirmation of nomination from bankruptcy trustee. Here it is only checking the confirmation. There is no comments of the bankruptcy trustee here. Okay, what we have seen in the insolvency resolution process. The insolvency resolution process, the RP before the admission is before the application is submitted, he reviews the application, provides the comments, which is not there here. It is straight away the appointment is happening here. The adjudicating authority shall provide the following documents to the bankrupt, creditor, and the bankruptcy trustee within 7 days of the passing of bankruptcy order, namely the copy of application for bankruptcy and the copy of bankruptcy order. The bankruptcy order passed by the adjudicating authority shall continue to have effect till the debtor is discharged under section 128. Effect of bankruptcy order. What will happen? On passing of the bankruptcy order, this is important. The estate of the bankrupt vests with the bankruptcy trustee. In the insolvency resolution process, the estate was still with the debtor. So he gave his repayment plan. Okay, but he was still running the assets. But here it is not the case. The assets comes into hands of the bankruptcy trustee. The estate of the bankrupt shall be divided among its creditors. So he will take care and divide it among the creditors. Subject to the secured creditor, the creditor of the bankruptcy trustee in respect of them shall not initiate any action against the property of the bankruptcy estate, commence any. So this is again the final moratorium. So first part is the estate comes into the hands of the bankruptcy trustee. Second part is moratorium. So till now what was interim moratorium, now it has become final moratorium. The bankruptcy order shall not affect the rights of the secured creditors. So secured creditors' rights will not be affected by the bankruptcy order, but the secured creditor shall not be entitled to any interest in respect of his bank debt after the bankruptcy commencement date if he does not take any action to realize the security within 30 days. So if he's taking over the assets, within 30 days, he's supposed to realize the assets, or else he's not going to get any interest on that. Order against the firm where the bankruptcy order is under section 126 is passed against the firm, the order shall operate as if it were a bankruptcy order against each of the individual partners on the date of order. So the order against the firm, suppose if there are 7 partners, it will be treated as an order against each individual also. Statement of financial position. Now, statement of financial position we have seen in the case if the application is filed by the debtor himself, he submits the statement of financial position along with the application. If it is filed by the creditor, obviously he doesn't have the statement of financial position. So now imagine if the application is made by the creditor, there is no statement of financial position. So what is the bankruptcy trustee going to do? He is going to take that statement of financial position from the debtor. So the bankruptcy application is filed by the creditor under 123. The bankrupt shall submit the statement of financial position to the bankruptcy trustee within 7 days from the bankruptcy commencement date. Okay. So if it is filed by the creditor, what if it is filed by the debtor? It is already included in the application. So where the bankrupt is a firm, the partner on the date of the order of such submit a joint statement of financial position of the firms, and each partner of the firm shall submit a statement of his financial position. So each partner wise as well as joint statement will be prepared. The bankruptcy trustee may require the bankrupt or any other person to submit in writing further information, explanation, or modifying any matter contained in the statement of financial position. Public notice inviting claims. Again, now the adjudicating authority shall send notice within 10 days from the bankruptcy commencement date. Mentioned in, there is a statement of affairs, the names are given there. Then mentioned in that application for bankruptcy submitted by the bankrupt under 122. So now this is statement of affairs submitted by the bankrupt under 122. So statement of affairs under 123, there was no statement of affairs. It was taken subsequently under section 129, the earlier section what we have dealt with. Okay. So in 122, the statement was there in the application itself. So this notice will be sent to all the list of creditors who are mentioned in the statement of affairs, and a public notice will also be given inviting claims. The public notice shall include the last date after which the claim shall be submitted and shall be published in a leading newspaper, one in English and one in vernacular language where the bankruptcy trustee resides. It should be affixed at the premises of the adjudicating authority and the website of the adjudicating authority. The same lines what we have seen under insolvency resolution process, similar lines. The claims are there. The public notice is there. Now, registration of the claims. The creditor shall register the claims with the bankruptcy trustee within 7 days of the publication of public notice. Preparation of list of creditors. The bankruptcy trustee shall, within 14 days of the bankruptcy commencement date, prepare a list of creditors of the bankrupt on the basis of statement of affairs and claims received. So the bankruptcy trustee has received all the claims. He will prepare the list of creditors within 14 days. The bankruptcy trustee shall, within 21 days of the bankruptcy commencement date, issue a notice calling for meeting of creditors. The notice shall state the date of meeting, which shall be not later than 21 days from the bankruptcy commencement date. Okay. Conducting the meeting of the creditors. The bankruptcy trustee shall be the convener of the meeting. Bankruptcy trustee shall decide the quorum and conduct the meeting only when the quorum is present. So only when the quorum is present, he can proceed further. Bankruptcy trustee following business shall be conducted. The establishment of the committee of creditors, the following business shall be conducted. Any other business that the bankruptcy trustee deals with. The bankruptcy trustee shall not adjourn the meeting of the creditors any purpose for more than 7 days at a time. So he cannot adjourn for more than 7 days at a time. Every creditor is assigned to a voting share. The creditor shall not be entitled to vote in respect of debt for unliquidated amount. Again, this is we are saying the creditor will be entitled to vote only for the liquidated amounts. The following creditors will not be entitled to vote. The creditors whose name is not mentioned in the list of creditors. That means if he has not submitted the claim form, okay, his name will not be there. And who has not given the notice by the bankruptcy trustee. Creditors who are associates of the bankrupt. The bankruptcy trustee shall convene the meeting of the COC of administration and distribution of the estate of the bankrupt. So that means the bankruptcy trustee is going to administer the estate. So because the estate has now come into the bankruptcy trustee, he is going to administer the estate. He is going to distribute the estate, and this administration and distribution report will be forwarded to the committee of creditors. The bankruptcy trustee will provide the COC with a report of administration of the estate of the bankrupt in the meeting of the said committee. The COC shall approve the report submitted to the bankruptcy trustee within 7 days of the receipt of the report and determine whether the bankruptcy trustee should be released under section 148. The bankruptcy trustee shall retain sufficient amounts on the estate of the bankrupt to meet the expenses of convening and conducting the meeting required under this section during the administration of the estate. So he should retain sufficient amount for convening the meeting. Finally, coming to the discharge order. So ultimate objective here also in bankruptcy is the discharge order. The bankruptcy trustee shall apply to the adjudicating authority for discharge order on the expiry of 1 year from the bankruptcy commencement date. So from the bankruptcy commencement date, within 1 year, it has to be closed. Within 7 days of the approval of the COC, within 137, that is, it can happen before also. The adjudicating authority shall pass the discharge order on the application made by the bankruptcy trustee. A copy of the discharge order shall be provided to the board for the purpose of recording the entry. Disqualifications of bankrupt. Now, since the bankrupt has, since the person has gone into bankruptcy, he is disqualified from doing certain things. What are those things? The bankrupt shall, from the bankruptcy commencement date, be subject to the following disqualifications: being appointed or acted as a trustee or representative in respect of a trust, estate, or settlement. So he cannot be a trustee. He cannot be appointed or act as a public servant. He cannot be elected in any public office where the appointment of such office is by elections. He cannot be elected or sitting or voting in any member of a local authority. Disqualification shall cease to have effect if the bankruptcy order is modified on 142 or he is discharged. So till the date he is discharged or till the order is modified, the disqualifications will be applicable to him. Now, restrictions. These are the disqualification. These are some of the restrictions which he cannot do or he is supposed to do. Okay, what are those restrictions? The bankrupt from the bankruptcy commencement date shall not act as director or be a part of promoter, formation, and management of a company. So he cannot be a director. Without the previous sanction of the bankruptcy trustee, be prohibited from creating any charge on the estate or take any future debt. He cannot create charge or take any future debt. He has to inform his business partner that he is undergoing bankruptcy. Prior to entering into the transaction of such value as may be prescribed, either individual or jointly, inform all the parties that he is undergoing a bankruptcy process. Without the previous sanction of adjudicating authority, be incompetent to maintain any legal action or proceedings in relation to the bankruptcy debts, and he cannot travel overseas without the permission of the adjudicating authority. What about the fees of the bankruptcy trustee? The bankruptcy trustee shall charge such fees as may be specified in proportion to the value of the estate of the bankrupt. The fee shall be paid from the distribution of the assets in the manner provided in section 178. 178 provides a waterfall model in which the fees has to be paid. So this is with respect to the bankruptcy order, okay, process. Now coming to the administration distribution, we have seen administration distribution part has to go to the COC, but actually how does it happen? What are the steps? Those sections are being done in 149 to 178 under chapter 5. So it is an extension of nothing but the chapter 4. Okay, because here it says the administration and distribution is done, discharge is done, but subsequently now we are coming through the administration and distribution. Okay. Now 149, the bankruptcy trustee shall perform the following functions in accordance with the provisions of this chapter: investigate into the affairs of the bankrupt, realize the estate of the bankrupt, distribute the estate of the bankrupt. So the estate has come to his hands. He is going to investigate the affairs. What is going to investigate? There are 4 types of transactions. Okay. Now there might be onerous contracts, preferential transactions, undervalued transactions. Okay. Okay. So such transactions, he is going to investigate the affairs. He is going to realize the estate of the bankrupt and he is going to distribute the assets of the bankrupt. Okay. Now, what are the duties of the bankrupt towards the bankruptcy trustee? So, the bankrupt, what are the duties? He is supposed to inform his affairs, whatever the additional properties he has acquired, or if he has devolved, suppose he has inherited any property in between, that has to be informed. In case there is an increase, that has to be informed. That all duties are there of a bankrupt. The bankrupt shall assist the bankruptcy trustee in carrying out his functions under this chapter by giving to the bankruptcy trustee the information of his affairs, attend on the bankruptcy trustee as times as may be required, giving notice to the bankruptcy trustee of any following events which have occurred after the bankruptcy commencement date: acquisition of any property, devolution of any property upon the bankrupt, increase in the income of the bankrupt, doing all other things as may be required. The bankrupt shall give notice of his increase in income or acquisition or devolution within 7 days of such increase, acquisition, or devolution. Devolution is nothing but inheritance. Now, these are the areas where the bankruptcy trustee has to take the explicit approval of the creditors, carrying on the business of the bankrupt, initiating or defending legal proceedings against the debtor, accept sale consideration at a future time, mortgage or sell any property for raising money for the payment of debt of bankrupt, arbitration or compromise with respect to subsisting debts, any compromise or arrangement as may be considered expedient, making payments or incur any liabilities with a view to obtain for the benefit of the creditors rights assigned to any assets, appointment of bankrupt to supervise the management of the assets, carry on the business, assist any transit. So these are the cases where approval is required. So that is the reason the bankruptcy trustee is like, the chairman of the committee, and he takes the regular approvals of the creditors. Vesting of the estates in the bankruptcy trustee. The estate of the bankrupt shall be vested in the bankruptcy trustee immediately from the date of appointment. The vesting shall take charge without any conveyance, assignment, or transfer. See, generally what happens is any transfer, it has to happen. It has to be by a registration process. Okay, here nothing like that. The vesting shall happen without any conveyance, assignment, and process. It is straight away by the fact the vesting will happen. The estate of the bankrupt shall include what? All properties belonging to or vested in the bankrupt at the bankruptcy commencement date. So whatever properties which were there with the bankrupt, with the capacity to exercise and to initiate proceedings for exercising all such powers in or over the respect of the property as may be exercised by the bankrupt in his own benefit at the bankruptcy commencement date or before the date of discharge order passed, and all properties which by virtue of the provisions of this chapter is comprised in the estate. So this all will include the estate of the bankrupt. It will not include what? Excluded assets. What are excluded assets? We have seen in the initial paragraphs. Up to such amount, any personal jewelry, one dwelling house, okay, and tools, equipments, all those excluded assets, what we have seen will not be included. Property held by the bankrupt on trust for any other person. So he is only holding as a trust for any other person. So this property you cannot take as to the bankruptcy trustee. All sums due to any workman or employee from the provident fund, pension fund, and gratuity fund. Such sums has been notified by the central government in consultation with the financial sector regulator. Now coming to restriction on disposal of property. Any disposal of property made by the debtor during the period between the date of filing the application for bankruptcy and the bankruptcy commencement date shall be void. From the date of filing the application and the bankruptcy commencement date, because once the bankruptcy commencement date has started, the estate becomes a part of the hands of the debtor. But during this period, if he had sold a property, the transaction becomes void. It is, you just see it's how hard the para is. Even if he has received such property before the bankruptcy commencement date in good faith for value and without notice of the filing of application for the bankruptcy, still it is void. After required. So this is before the bankruptcy commencement date. What about the after required property of the bankrupt? The bankruptcy trustee shall be entitled to claim from the estate of the bankrupt any after acquired property by giving a notice to the bankrupt. A notice shall not be served in respect of excluded assets. So once if it is after acquired property, the bankruptcy trustee shall be entitled to claim. He should serve the notice, and the notice serves in respect, it should not be in respect of excluded assets or any property which is acquired by or devolves upon the bankrupt after discharge order is passed under section 138. Or once the discharge order, so see, before the bankruptcy commencement date or application filing and the bankruptcy commencement date, all such transactions are void. Between the bankruptcy commencement date and discharge order, he himself has the right. After the discharge order, he can have all the assets he wants. There is no harm. Notice shall be given within 15 days from the date on which the acquisition or devolution of such after acquired property comes to the knowledge of bankruptcy trustee. The bankruptcy trustee shall not be entitled by virtue of this section to claim from any person who has acquired any right over after acquired property in good faith for value without notice of the bankruptcy. See, same section before the bankruptcy commencement date and after the application, such transactions were straight away void. But after acquired property, okay, there in the bankruptcy, if it is sold by virtue of this section and it was acquired in good faith, then the bankruptcy trustee will not be entitled for this property after acquired properties. Now coming to the 4 transactions: onerous transactions, undervalued transactions, preferential transactions, exhausted credit transactions. What is the onerous transactions? Onerous transactions are those transactions which are not profitable, or where if I sell them, the amount recoverable will be less than the cost which will be made to make them ready for sale. So the bankruptcy trustee, by giving notice to the bankrupt or any person interested in the owner's property, disclaim any owner's property which forms part of the estate. So he will say, I'm not going to sell them. He is disclaiming them. Okay. What is the owner's contract? As I've said, it is unprofitable contract and any other property comprising in the estate of the bankrupt which is unsaleable and not readily saleable in such manner as may be rise to a claim. Now coming through these 3 transactions: undervalued transactions, preferential transactions, exhausted credit transactions. What is the undervalued transaction, sir? Suppose what happened is any transaction which is done for a very substantial amount. Suppose the sale was to be done for 50 lakhs. The sale transactions happened for 10 lakhs only. So I have received only 10 lakhs. So it becomes a undervalued transactions. Preferential transactions, what happens is list of creditors has to be paid. Rather than paying everyone, a preference was given to one creditor in making the payment. So generally what I'll do, I'll try to see that whatever my related persons are there or some people who are troubling me more, I make the payment to them first. That is called as a preference transactions. Extraordinary credit transactions are those transactions rather than making undervalued transactions. What I do is I take a loan and make the exorbitant interest on those transactions. So if such transactions are there, the RP is supposed to, the bankruptcy trustee is supposed to get into these transactions. And in the case of undervalued transactions, he has to see whether have they been made within 2 years from the application for bankruptcy. And because of that, the trigger has happened. Then he can make an application to make it void. Preference transaction, he has to see if it is between a preference is given to an associate, is a related person within 2 years. If it is not an associate, within 6 months from the ending from the filing of the application for bankruptcy, from the date of application, go back 2 years and 6 months. If any preference is there, he can make an application to adjudicating authority to make those preference transactions void or take over the assets as they were earlier. Exhausted trade transactions. Here also, if such transactions were entered into between 2 years from the date of making an applications, the bankruptcy trustee may make an application to the adjudicating authority for making it void. So this is where the paragraphs are, the 164. I'll just explain, so I'll skip them: 164, 166, and 167. Now coming to 169, continuation of the proceedings on death of a bankrupt. Section 169, if a bankrupt dies, what will happen? Nothing but the bankruptcy proceedings will continue as if he was alive. Okay. Now how the payments will going to happen, the priority of the payments. So 178 talks about the waterfall model. So how the payments will happen. So first the payments will go to the cost and expenses incurred by the bankruptcy trustee for the bankruptcy process. So during this process, the bankruptcy trustee has been working. So whatever cost which have been there on the bankruptcy trustee will be first given to him. Second, it will come to workmen used for 24 months prior to the bankruptcy commencement date. That's due to secured creditor. Now, what is the secured creditor? Why is secured creditor coming to picture? See, secured creditors, we have already seen, he's totally outside. Secured creditor has the option to relinquish his right. Once he is relinquishing his right, he becomes a part of the creditors and he is given a priority in the waterfall model. So he's going to the second level, second layer. Then coming through the next waterfall. So first will be paid is cost, workmen and secured creditor. Here it comes to employee dues, wages and unpaid dues to employees other than workmen for a period of 12 months prior to bankruptcy commencement date. So workmen will given preference to 24 months. employees were given preference for 12 months. Then coming to government dues, any government dues for central and state government for 2 years preceding the bankruptcy date. And finally, all other debts included as unsecured debts. This is how the waterfall model is going to be. Now, a brief comparison between the insolvency resolution process and the bankruptcy process. See here, both the cases we have seen finally the debtor is discharged, but the process is different. So here in insolvency resolution process, there should be a default. In the case of bankruptcy, there should be a trigger. What are the trigger? The 3 points for the trigger. So necessary condition, default by the debtor. In the case of bankruptcy, rejection of application for insolvency resolution or rejecting a repayment plan, premature termination. So these are the 3 trigger sections wherein within 3 months, then application has to be made for bankruptcy. Who is eligible? Debtor and creditor. Here also debtor and creditor. In one case, only creditors. What is the section 104? Wherein under insolvency resolution, the RP rejects the application under 10(4), seeing say this is made to defraud the creditors. In that case, the creditor himself can file. Now, dominant aspect is there is a repayment plan insolvency process. Here, the administration distribution of the asset is there. Both the cases we have interim moratorium. Both the cases role of insolvency professional is there. Here, earlier case we called this as a resolution professional. Here we call this as a bankruptcy trustee. Both the cases moratorium is also there. Vesting of the estate doesn't happen in the insolvency process. Vesting of estate comes in the process of bankruptcy only. Discharge also, both the cases it happens. Whereas in the case of no default period is specified, early discharge was possible. Here, the default period of 1 year from the bankruptcy commencement date or the commencement of administration is approved by creditor, which was earlier. Excluded debt are not considered in both the cases. Stage of order is nothing but insolvency, repayment plan, successful implementation, discharge. Here, insolvency, repayment plan, failure, then bankruptcy is triggered and then discharge happens. Now coming through the 6th chapter, which is for adjudicating authority for individuals and partnerships, section 179 to 183. Now here in the case of individuals and partnerships, who is adjudicating authority? In the case with respect to guarantors for the corporate debtor, it will be the NCLT, whereas other cases it will be that recovery tribunal having the territorial jurisdiction. So administrative authority for individuals and partnerships, debt recovery tribunal having territorial jurisdiction over the place where the individual debt or actually and voluntary resides or carries on business or personal works for gain and can entertain an application under this code regarding such place. DAT is okay. Which place? Where the individual debtor actually resides. So you follow the data. See, in CRP, we have to go with the NCLT where the corporate debtor's registered office is situated. Here, you see where the registered individual debtor resides. To this place, the petition will go. Civil courts will not have any jurisdiction. No civil court or adjudicating authority have jurisdiction to entertain such suit or proceedings in respect of any matters on the DRT, DRAT has jurisdiction under this code. In between, high courts were giving writ petitions were filed. Subsequently, the Supreme Court had given directions to the high courts also not to entertain any writ petitions also. Appeal to, so in case if it fails at DRT, the next appellate authority is DRAT, that recovery appellate tribunal. The application for the order of the DRT under the code shall be filed within 30 days before the that recovery appellate tribunal. So it has to be filed within 30 days. The DRAT may, if it is satisfied that the person was prevented by sufficient cause from filing an application within 30 days, may allow an appeal to be filed with a further period not exceeding 15 days. So you can remember as 30 plus 15. Appeal to the Supreme Court straight away. Now the final apex body is Supreme Court. An appeal for an order of the DRAT on the question of law under the code shall be filed within 45 days before the Supreme Court. The Supreme Court may, if it is satisfied that the person was prevented by sufficient cause from filing an application within 45 days, allow the appeal to be filed within further period not exceeding 15 days. So 45 plus 15. expeditious disposal of applications. Where an application is not disposed of or the order is not passed within a period specified in this code, the DRT or the DRAT, as the case may be, shall record the reasons for not doing so within the period so specified, and the chairman of the DRAT, after taking account the reasons so required, extend the period specified in the code but not exceeding 10 days. So this is basically trying to put a pressure on the tribunals to pass the orders faster way. But basically what we have seen is in the case of CRP, all these timelines were taken as recommendatory and not mandatory, because in CRP also the NCLT has to pass the order within 14 days. And there are cases for more than 2 years there. And we have seen 2 COVID times coming in. So now we have in the NCLT cases pertaining to 2019 also, which is presently going on. Offenses and penalties. Coming to the last chapter, chapter 7. So rather than having each section wise, I have prepared as a table. Description and penalty, how much is the amount? 184.1. Debtor of the creditor provides false information to RP. So the penalty is up to 1 year or up to 5 lakhs or both. Creditor votes in favor of RP dishonestly 2 years, 3 times, and if the amount is not quantifiable, it is 5 lakhs or both. RP deliberately contravenes up to 6 months, 1 to 5 lakhs or both. Bankruptcy fraud misappeared, bankrupt fraudulently misapplied, retained or accounted up to 3 years, 3 times, and if it is not, amount is not quantifiable, 5 lakhs or both. So you might have a case study on these lines on penalties. Okay. So bankrupt knowingly makes false representation under 122. 6 months or up to 5 lakhs or both. Bankrupts fail to provide or withheld books of accounts 1 year, 5 lakhs or both. Bankrupt contravenes restrictions under 140, 141, 6 months, 5 lakhs or both. Bankrupt failed to deliver possession under 160, 156, 6 months, 5 lakhs or both. Bankrupt failed to account for loss 12 months before filing bankruptcy, up to 2 years or 3 times, and the amount is not quantified, it up to 5 lakhs. Bankrupt absconds or attempts to abscond to 1 year or 5 lakhs or both. Bankrupt fraudulently misapplied, retained or accounted 3 years, 3 times, and not quantifiable, 5 lakhs or both. So these are the penalties which are provided. And if you have some doubts, we can take up. Okay. Let's see some questions if they are there. Okay. So what my suggestion of writing the exam is, see that once the study is completed, okay, write the exam. Don't have much time between 2 attempts, okay, because what happens is once you have written, you have studied the entire code, and if you give a gap of 2 weeks, then what you will read will be less and what you will forget will be more. You just imagine, see this presentation probably I'm taking for around 6 or 7 times, but sometimes every time I see I forget some points, okay, then again, but overall we know, but so this is what will happen. So ensure that whenever you are writing, suppose you are not able to make it in one attempt, immediately go for a next attempt, get the dates for the next attempt and write it, and ensure that the time gap is less, okay. And I would, the course is not very tough, okay. The only thing is it needs around a dedicated 20 to 25 days of studies, and with this you can easily crack it. So this is what from my side. I thank the SRC once again for giving this opportunity, and thank you, Revati. Over to you, Revati. Thank you.
Yeah, thank you very much, Ritesh. That was a very fabulous session on this individuals and partnerships, and also thanks a lot for giving this exam tips. Yeah, somebody is asking when will the exam inform? Would you like to clarify, Ritesh, about how to register for the exam and all that?
See, straight away you can go to, I'll just share the screen here.
This exam is not going to be conducted by SARC, it will be conducted by IBBI, and Ritesh will run you through the registration process for the exam.
So this is the website of IBBI. Now, how do I register? How do I attend for the exam? So you have to go to the examination tabs. Okay. In the examination tab, you have this limited insolvency examination. Okay. Click on the limited examination from 1st of January 2021. Then you have this register and enroll online. Okay. Just click yes, I agree. Proceed further. Okay. So you have to create a new user. Okay. So this is the website of the IBBI. You have to create a login. Okay. So you'll get a user ID and password. Then once you have done that, you can click on the registration centers, user ID and password. Then the third option is if you want to know what are the center dates and details. So you can select the dates, for example, Tamil Nadu. I select Chennai. What are the slots? Okay. So here for viewing the slot availability, okay, Tamil Nadu, select city Chennai, check the time. There are again 4 slots, 16th August. So here the seats are available at these times. You can straight away select those slots. It will ask you to log in. You have to pay the fees of 1500 per each slot. So this way you can check the slots availability. Okay. As far as I understand, you will be able to select one slot, and after the writing the exam, once you come to know that you are not able to make it, only then you will be able to select for the subsequent slot. So now if you see 16th, 19th, 23 and 30. So 16th, 19th, 23 and 30. So basically every third day the slots are there. So it's not possible for you to write the exam immediately, because once you immediately write, that day slots will already be taken away. So minimum 3 days time will be there to catch up with the next slot. So this is how you have to register for the slots, and try to possible do as many MCQs are there, and read the entire code at least once, line by line has to be happen, and try to see that. So this is how the registration enrollment sample questions. One model paper is also given here. Okay, so get see that at least around 10 to 15 model papers you are able to do before writing the exams. Okay, and here we have the syllabus is given. Lot of other acts are also there. So at least see, when it comes to IBC, you have to read the IBC thoroughly. Other acts, what you can do is you can prepare a gist about each, like for example, Companies Act. If you start reading the Companies Act, it will take around 3 months totally. Okay, so each chapter wise prepare some gist, summary, and then
actually
some MCQs.
we are having a session on other acts also.
Okay, super.
So it will be taken by Ramana, the CA and advocate. He will be taking a session. It will be quite simple. People will be able to answer the questions on other act once his classes are taken.
Yes. So this is with respect to the process of registering and appearing for the examination.
There's a question here. Understand that exam will be conducted based on law as on 2020, since earlier edition of books are not available. Any suggestions? No, actually, if you see the screen which Ritesh showed us, there is a syllabus. If you go to the syllabus, right at the bottom, it will be say up to 31/3/20. So you go back to the website and you go to that legal framework. Okay. And there you can download the act, the regulations, everything up to 31/12/2020. Don't take the subsequent amendments. Just take this as on 24/9/2020. Whatever is the code, download that PDF file and you can go through it. You don't need to know what is there earlier or what is there after. Whatever is there in the code as on 31/3/2020, which will be this 23rd September PDF file, download it and go through it. Similarly, for everything, for the rules, the regulations, all of these separate individual CIRP regulations, I think is also available only up to 23(9). Then you have the liquidation regulations, IP regulations, IPA regulations, code of ethics, and also there was a booklet on code of ethics which was issued by IBBI. Then go through the circulars. All these, you just have, all the material is available on the website, so you can very easily go through it and do it. Okay, there is one more doubt. We need your good offices to reactivate the IBC exam resources. Yeah, actually the exam resources, what I was told is if you pay some 500 rupees, you would be able to activate and go through those resources. In case you have any problems, please do let me know, because I checked out with Triple IP. They said that now it's a paid option. Earlier, people who were registered were given a user ID and password and they were able to access. That is how we all also prepared. But now it's a paid option. E-learning website, you have to go through the e-learning and get it done. You have any problems, please do get in touch. Okay, yeah, please try again, sir. And in case of any problem, send me the screenshot by email. I will take it up with the Triple IP. See, actually, you don't need to buy any books or anything. You can go through all, like how Ritesh said, work out all the model question papers which are available on the all the 3 Triple IPs. IBBI website, it is there. Plus, I think now there are a lot more available. If you Google, you will be able to get. Case laws, again, we have Ashish Makija sir going to take a session. If you go through those case laws in the manner in which he speaks, I think you'll be able to do the case laws very easily. 20 marks, no case laws. So you should be able to do, no, I think it's 10 marks. You should be able to do it very easily. You will not be able to get any previous questions and answers because IBBI keeps a proprietary hold on to the questions. We cannot copy the questions also because, as we told you, you'll have only one sheet of paper. Whatever the people who write the exams remember, that they share and we collate and we use it, we share it as we are doing the, sessions. So, Ritesh, you have any access to any previous questions?
Previous questions not there, but many of the books now they are there, like you are giving good number of questions there. And the issue is these questions also keep changing in every 3 to 4 months. So what it is better is if you are, if there is a group of around 50 to 100 people who are writing the exams, once you write the exams, at least try to remember around 15 to 20 questions.
Yeah.
Irrespective of the fact whether you have passed or failed, post those questions in the group. So if in such cases, what happens is everyone starts putting those questions in the group, especially for other acts and general acts. This will be very helpful because every time when you see that you are writing the exam, you'll see that 2 to 3 questions are repeating. Yes. So what happens is in case such questions, if you find them in the groups and then you find, the answers there. So it will be helpful. So try to join those WhatsApp groups where the members are writing exams.
True. Actually, we will also ask SARC to create a group for this particular group of participants. So as people start taking up the exams, they can share the questions within the group. And we also, in case we get any further questions, we will definitely share them. But, there is no need for you to go for those questions because as Ritesh said, the questions do keep changing. There'll be around 10 to 15% of the questions will be a repeat, which is definitely going to help us. But those would be the direct questions on the code or the regulations, which if you are thorough, the idea is you should be thorough. And like how all the faculties have been saying, prepare the charts, timeline charts, number of days, and how Ritesh was telling, go to the index and do it. We have the book that we all used is this Commercial Law Publishers. Can you see it? How do I hold it like this? Yeah.
No, the other side, yes. The other, yes. Commercials has the index for regulations and.
It has. It's by Virag Gupta.
Yes.
So you just go through it. You get this book. But the thing is, if you take the latest book, you'll have all the latest amendments. So you might get a little confused.
There are not many amendments actually, if you see, except for that pre-pack insolvency. So anyway, in the bottom, it will be written that when it has come. So those you can just ignore.
Yeah, you have to see the footnotes.
Not many amendments have come there, thankfully, because we earlier.
Download the code from the
from the
site.
code. But generally that the book form will have more easy access rather than each individual papers, and then again it will become a difficult to have an index for that. So the Bare Act will have a ready-made index for each regulations, and we know what it has to be covered. So that is better to take latest Bare Act. Not many differences are there, except for the certain sections like pre-pack has been recently introduced, and
the applicability. What is the minimum amount of default? And the personal guarantors and all that. Yeah, the book will cover the entire syllabus with reference to the code and the regulations. Other acts will not be covered in this book. But there will be some certain discussion points which will be very useful for understanding also. When we had the physical classes, we all had the luxury of taking our books and highlighting whatever the faculties told us at that point in time. And I hope that if you had taken down the notes, you would have also been able to highlight it in your books and go with it. If you don't have the book, download it from the website. That is the best way to go about it. And of course, if you go through all the 3 IIIP websites, there are a lot of discussions. Okay, and there are topic-specific articles will be there. I have seen in both IIIP of ICAI as well as ICSI, there are a lot of topic-specific articles and discussions. So you can just go through that. See, Bare Act is what not
commercials you can have. Commercials you can go for the
commercial law publishers. Virag Gupta.
Yes.
I typed it in the chat.
Because what I understand is commercials has the Bare Act for even the regulations and the rules. They have the index specifically, which is missing in the taxman book.
Yeah, they have
taxman. The index is given only for the code taxman.
Yeah,
not for the regulations.
So you can just get this book. It'll be useful to you. And to keep up with only the exam syllabus, download the code and match it along with the book so that you will know that what are all the amendments which are not relevant for your exam, which is going to be very few, as Ritesh told. Yeah. Okay. So in case there are no further questions, I think we will close down today's session. Thanks a lot, Ritesh, for sparing your time as well as
this wonderful opportunity.
Sharing your knowledge with everyone and taking
I wish all the best to everyone.
Yeah. Okay. So thank you very much to all the participants also. We will meet again tomorrow for the next session. Same time, 10 o'clock. Yeah. Okay. Thank you very much. Tomorrow we will have the other balance regulations, which is going to be handled by a company secretary. He'll also give you his take on the exam as well as the prep. Yeah. Thank you very much. Yeah. Thanks a lot.